Good afternoon, guys. Please confirm, is the audio video clear? Shall we begin? Yes. Perfect. So let's start. I'm not sure about you, but I'm pretty excited about this session. It's going to be a lot of learning, a lot of revision. We're going to be revising 50 concepts, all right? 50 concepts, which according to me are like category A concepts for your examination. All right. Now, let me give you a small disclaimer before I start. I am not saying that you should be studying just these 50 concepts and you will pass the examination. There is no, assurance that your entire question paper will be only filled with these 50 concepts. And nor, see, there is a chance, there is a possibility that not even one of these 50 concepts come in your examination. Or there is a possibility that your examination may have, probably 90% of your question paper may come from these 50 concepts itself. So either way is possible. This is just our analysis, having a look at, the past examination question papers, the mock test papers, the revision test papers, looking at all of that, looking at, all of that analysis, we have, sort of come up with these 50 concepts. All right. Now, apart from these 50 concepts, which we are going to be discussing today and tomorrow, I hope you guys have received this file where we also have a list of another 50 sections, set B. So totally there are 100 concepts, okay, or 100 sections, I would say. So what we are going to be doing today and tomorrow is the first 50 sections. All right. In addition to Signi 50, I've made another list of another 50 sections, the second 50, which you can handle on your own. So total around 100 concepts I have, a sort of shortlisted. These 100 concepts have to be done like really, really well. All right. So out of these 100 concepts, the top 50 we're going to be discussing in today and tomorrow's session. So are you ready, guys? Shall we start? Shall we begin? Yes, let's begin. Let's make the most of a session today and tomorrow. It's going to be a lot of revision. All right, let's begin. So our very first discussion, our very first concept, by the way, I am starting with Companies Act first, and then I'll move to other laws. All right. So under Companies Act and the basics and kinds of companies discussion, my focus is right now on, just a moment, whoever is drawing on the screen, please stop doing it. There's a question in the chat box. Pravina is asking, can you please share the PDF in the chat? Pravina, you don't need this PDF right now, all right? I'm anyways going through it one by one, so you don't really need it right away. You will anyways have this available in my Telegram channel also. I've uploaded it there as well. You can take it from there. All right. So right now I'm starting off with my discussion. So we're going to start with listed companies and unlisted companies, our very first discussion. This was not a very important concept until long ago, but after the amendment in this particular concept, this has become extremely important. So listed and unlisted companies are our very first discussion. Did I share the notebook? I hope you're able to see the notebook, guys. Yeah, listed and unlisted companies. Now listen, when I talk about listed companies are those companies whose securities are listed on some recognized stock exchange, right? Recognized stock exchange, for example, either BSE or NSE, but they have to be listed on some recognized stock exchange. On the other hand, unlisted companies are those companies whose securities are not listed on any recognized stock exchange. In addition to this, I have 4 more companies. These 4 companies, even though they have listed some security, they will not be considered as listed companies. In other words, I have 4 companies which will be considered as unlisted companies only. Now, what are those 4 companies? Listen to me. Number 1, in case we have public companies who have not listed their equity shares, but they have listed non-convertible debentures which they had issued on private placement basis. Number 2, public companies who again did not list their equity shares, but they have listed non-convertible preference shares which they had issued on private placement basis. Number 3, again, I'm talking about public companies who have not listed their equity shares, but they have listed non-convertible debentures and non-convertible preference shares, which they had issued on private placement basis. And number 4, we have private companies who have not listed their equity shares, but they have listed their non-convertible debentures, which were issued on private placement basis. So my very first discussion over here, listed companies are those companies whose securities are listed on some recognized stock exchange. Unlisted companies are those companies whose securities are not listed on any recognized stock exchange. Unlisted companies will also include these four. These four will be considered as if they are unlisted companies. Number 1, public companies who have not listed their equity shares, but they have listed their non-convertible debentures, which were issued on a private placement basis. So guys, are you noticing 4 things, 4 keywords you have to write? Number 1, public company. Number 2, did not list equity shares. Number 3, listed non-convertible debentures. Number 4, issued on a private placement basis. Then second situation, again public company, it has not listed equity shares, but it has listed non-convertible preference shares, which were issued on a private placement basis. And then number 3, again public companies which has not listed equity shares, but has listed both non-convertible debentures and non-convertible preference shares, which were issued on a private placement basis. And lastly, I have this time private company which has not listed equity shares, but has listed non-convertible debentures, which were issued on a private placement basis. All right, so these 4 companies, even though they have listed some securities in the stock exchange, I am going to treat them as if they are unlisted companies. Now keep this concept in your mind and have a look at this question. This question over here, which you see, is a recent November 2022 5 marks question relating to listed and unlisted companies. We just have to identify, are they listed or are they unlisted? Look at the first question here. ABC Limited, a public company, has listed non-convertible debentures issued on private placement basis in terms of SEBI Regulations 2008. Listed company or unlisted company? It has listed some security, but it is a public company. It has listed non-convertible debentures, which was issued on a private placement basis, but it has not listed equity shares. So this is definitely going to be an unlisted company. Then second situation, CHG Limited, a public company, it has listed non-convertible redeemable preference shares issued on a private placement basis. In terms of SEBI issue and listing of non-convertible redeemable preference shares regulations 2013. Again, this company has listed some securities, but it is a public company. It has listed non-convertible redeemable preference shares, which were issued on a private placement basis, and it has not listed equity shares. So again, this company will be considered as an unlisted company. Are you understanding? All my 4 conditions are getting fulfilled. It's a public company, all right, and it has not listed equity shares, but it has listed debentures or it has listed preference shares on which were issued on a private placement basis. This will be considered as an unlisted company. Now, the reason why I'm discussing this question with you is a third subdivision, which is the most interesting subdivision. We will read the subdivision. As soon as we finish reading this, your answer should be ready. PRS Limited, a public company which has not listed equity shares on a recognized stock exchange, but whose equity shares are listed on a stock exchange in a jurisdiction as specified in Section 23(3) of the Companies Act 2013. What do you think about this? It's a public company. It has not listed equity shares on a recognized stock exchange, but equity shares are listed on some stock exchange in a jurisdiction as specified in Section 23(3). See, for a moment, as of now, let us say we don't know what is Section 23(3). The question is saying that equity shares are not listed. They are not listed on a recognized stock exchange. Instead, they are listed on some stock exchange, some 23(3) stock exchange. We don't know what is 23(3), let us say. We can still answer. The question clearly says equity shares are not listed on a recognized stock exchange. That itself indicates what? It's not a listed company, guys. Because listed company means securities has to be listed on a recognized stock exchange. Here it is listed on some other stock exchange, but it is not listed on a recognized stock exchange. So even this will become an unlisted company. Now, just for your information, Section 23(3) is nothing but a foreign stock exchange. Like, for example, you have the NASDAQ of the US. So you haven't listed your securities in Indian stock exchange, but you're listing your securities in some foreign stock exchange. Even that will be considered as unlisted company. Because I will call you as a listed company only if you list your equity shares in a recognized stock exchange. Is this crystal clear, guys? Yes. So taking you back to my theory over here, a listed company is a company whose securities are listed on a recognized stock exchange. This was the whole decision-making factor in the third concept. All right. In the third concept, we had listed our securities not on a recognized stock exchange. On some other stock exchange, we had listed, but not on a recognized stock exchange. And that is why it was not a listed company. If it is not a listed company, it will automatically become an unlisted company. Are we crystal clear with this discussion? Can I close my very first discussion? Yes, guys. Now, in my first discussion, I wanted to discuss with you not only about listed and unlisted companies, I also wanted to discuss with you about small companies. In my very first point, the very first topic, I have taken both listed and unlisted companies as well as small companies. Now, listen to my next discussion. I'll call this as point A, and now point B, I'm discussing with you about small companies. Listen, small companies is important because, as you know, it has been amended. Amendment is applicable for the first time for your examination. So what are these small companies? They are companies which fulfill two criteria. Number one, their paid up share capital should be not more than 50 lakhs. This is as per the Act. But the Act is giving the power to the central government that if the central government wants, the central government can change this number. They can increase this number up to 10 crores. The central government has exercised this power and they have increased the number to 4 crores. Then paid up share capital is one condition. Another condition is turnover. Turnover, according to the Act, should not exceed 2 crores. But the Act has given the power to the central government that if the central government wants, they can increase the turnover number up to 100 crores. And the central government has exercised this power and they have increased the limit to 40 crores. So as on date, what are the numbers? The paid up share capital should be less than or equal to 4 crores and the turnover should be less than or equal to 40 crores. All right, guys, come on, keep repeating along with me. All these concepts you are doing in the last 1 month before the examination. So the day before the examination, all of this should happen really quickly. All of this revision should happen really quickly. Aishwarya saying voice is not clear. Is it so for everybody? Is everybody facing a problem with the audio? No, it's perfectly clear, right? So Aishwarya, I think you'll have to check at your end. So anyways, coming back to my discussion, small companies are companies whose paid up share capital does not exceed 50 lakhs and turnover does not exceed 2 crores. The Act has given a power to the central government that if the central government wants, they can increase the 50 lakh number to 10 crores and this 2 crores number to 100 crores. The central government has exercised this power and the paid up share capital number has been increased to 4 crores and the turnover number has been increased to 40 crores. You should be remembering all the 6 numbers. Understanding, guys? One last time, what are the 6 numbers? As per the Act, 50 lakhs and 2 crores. The central government power is 10 crores and 100 crores and the central government has exercised this power, paid up share capital not more than 4 crores, turnover not more than 40 crores. But there are 4 companies which will not be considered as small companies. There are 4 companies which will not be considered as small companies. Number 1, we have public companies. Number 2, we have holding companies and subsidiary companies. Number 3, Section 8 companies. And number 4, we have the statutory companies. These companies, even if they fulfill both the criteria, even if their paid up share capital is within 4 crores, even if their turnover is within 40 crores, these 4 companies will never be considered as small companies at all. Okay, so what are small companies? Their paid up share capital should be within 4 crores, their turnover should be within 40 crores. All right, public companies, holding companies, and Section 8 companies, statutory companies, these companies will never be considered as small companies. All right, so this is it with my very first concept over here relating to listed and unlisted companies as well as small companies. Okay, remember, listed and unlisted companies, we said listed company is a company whose securities are listed on a recognized stock exchange. Guys, will you remember the significance of this word recognized? This you cannot write just stock exchange. Okay, if you write shares listed on a stock exchange, gone, no marks. You'll have to write securities, securities listed on a recognized stock exchange. Okay, and then we learned that unlisted companies are those companies whose securities are not listed on a recognized stock exchange. And then we saw 4 companies, even though they have listed something, but because they did not list equity shares, I am not considering them as listed companies. I am considering them as unlisted companies. And then we have learned about small companies. So this was our first discussion. Now taking you to the next discussion, we're going to be learning about section 10A. Section 10A is a concept which is a part of your incorporation of companies, incorporation process. All right, let me discuss the section with you. This is an important section. Not only is the section important, even the penalty over here is important. Okay, so listen to me. What are we talking about? Section 10A. Section 10A is a part of your incorporation process. I hope you remember the incorporation process. In step 1, we do the name reservation, guys. And can you tell me the name reservation is going to be valid for how many days? Name reservation is generally valid for around 20 days, right? And for an existing company name reservation is valid for how many days? 60 days. If a new company is doing name reservation, it will be valid for 20 days. Existing company is doing name reservation, it will be valid for 60 days. Then second step is drafting, signing, stamping, MOA, AOA and all. Then step 3, you file some documents with the ROC, and then you file all these documents with the ROC. ROC gives you a certificate of incorporation. So listen to me, ROC has already given to the company a certificate of incorporation. In this certificate of incorporation, 2 very important things are written. Number 1, the corporate identification number of the company, and number 2, the date of incorporation of the company. This certificate of incorporation is a conclusive evidence that the company has been incorporated. Now, this point onwards, nobody can question the incorporation of the company. But listen, even though the company has come into existence, even though the company has received certificate of incorporation, this company cannot commence business. This company cannot exercise borrowing powers. It cannot commence business. It cannot exercise borrowing powers till it fulfills 3 conditions written under section 10A. You're understanding, guys? You're understanding the background behind my concept? Are you able to recall all of this? Yes, what is my situation over here? The ROC has filed certificate of incorporation. The ROC has given certificate of incorporation to the company. The certificate of incorporation already has the corporate identification number, also has the date of incorporation. It is a conclusive evidence that company has come into existence. Even though company has come into existence, still the company cannot commence its business, still the company cannot exercise borrowing powers till it fulfills 3 conditions. Now, what are the 3 conditions? Listen to me. The very first condition, the director has to give a declaration to the ROC. The director has to file a declaration with the ROC. What declaration? A declaration saying that the subscribers have all fully paid for the shares taken up by them. Subscribers have fully paid for the shares which they have taken up. Listen to me. Let me explain this to you. See, you know who the subscribers are. The subscribers are the persons who sign the MOA. Now, these subscribers, it is mandatory for them that they have to take minimum 1 share. Now, if they're taking that minimum 1 share, will we give them that 1 share for free, guys? Of course not, isn't it? We will give them the share only, obviously, for some consideration. So those subscribers have to fully pay for the shares taken up by them. So the very first point, the directors have to give a declaration to the ROC that yes, the subscribers have fully paid, they have fully paid for the shares which they took up. Now this declaration has to be filed with the ROC from the date of incorporation. Within 180 days itself, we have to file this with the ROC. If we don't file this declaration with the ROC within 180 days, then ROC may also remove the company's name from the register of companies. ROC may also declare the company as non-existent anymore. The company may come to an end if this declaration is not filed within 180 days. So if this is not filed within 180 days, then ROC may even remove the company's name from the register of companies. All right, so this was my first condition. Then talking about the second condition, in case I am a company which requires some approval. For example, if I am a bank, I need RBI's approval. If I'm an insurance company, I need IRDA approval. If I'm an electricity company, I need the electricity board's approval. So if I require any such approval, even these approvals we have to obtain, and we have to file these approvals with the ROC also. Number three, from the date of incorporation within 30 days, the company is supposed to give to the ROC verification of the registered office. Verification of registered office is nothing but fancy terminology for address proof. Address proof of the registered office has to be given to the ROC. Understanding. So repeating this entire thing once again, listen to me. Section 10A says that there are three conditions have to be fulfilled. Only then the company can commence business, only then the company can exercise borrowing powers. What are the three conditions? Condition number one, the director has to file a declaration with the ROC, a declaration saying that the subscribers have fully paid for the shares taken up by them. All right, the subscribers are none other than the persons who are signing the MOA. These subscribers have to at the minimum take one share, and obviously we will give them these shares only for a consideration. So the subscribers have to pay the consideration. The directors have to give a declaration that yes, the subscribers have paid the consideration, and this declaration has to come within 180 days. So the directors have to file a declaration within 180 days from the date of incorporation of the company, a declaration saying that the subscribers have fully paid for the shares taken up by them. If this declaration is not filed within 180 days, then the ROC may even remove the company's name from the register of companies. Then second point, in case any approval is required, even the approval has to be filed with the ROC. And number three, from the date of incorporation within 30 days, we have to file the verification of registered office with the ROC, and verification of registered office is nothing but the address proof of the registered office. It has to be filed with the ROC. Okay. So this is it about section 10A. But listen, what if my company does not follow section 10A? What if there is a non-compliance? What if there is a default? In that case, there will be a punishment. And what will the punishment be? The company will be punished, and not only the company, even the directors and officer in default will be punished. The company will be punished with a fine of rupees 50,000, and the directors and officers in default will be punished with a fine of rupees 1,000 per day of default. They will be punished with a fine of rupees 1,000 per day of default, but the maximum punishment that I can give them is rupees 1 lakh. All right, so this was my entire discussion regarding section 10A, giving you one last revision of section 10A. Listen to me. Even after getting the certificate of incorporation, the company cannot commence business. It cannot start exercising its borrowing powers till it fulfills three conditions. What are the three conditions? Number one, the director has to file a declaration with the ROC saying that the subscribers have fully paid for the shares taken up by them. This declaration has to be filed within 180 days from the date of incorporation of the company. Then number two, in case any approvals are required, even approvals have to be filed with the ROC. Number three, from the date of incorporation within 30 days, we have to file the verification of registered office with the ROC. And then in case there is a non-compliance, in case any of these rules are not being followed, then the company will be punished with a fine of rupees 50,000, and the directors and officers in default will be punished with a fine of 1,000 rupees per day, and the maximum fine is going to be rupees 1 lakh. Perfect understanding, everybody? Yes, did you understand this penalty is very, very important. Okay, company will be punished with 50,000, director and officer in default will be punished with 1,000 rupees per day, maximum being rupees 1 lakh. So this is it about my second concept about section 10A. All right, now I'm discussing with you two concepts from the MOA and AOA discussion. The third concept, this is going to be about alteration of MOA. If I want to alter the MOA, what are the rules and regulations that I have to follow? What is the process that I have to follow? The MOA and AOA chapter is important from the examination perspective. You do get some question from here for not too many marks, but for some, at least like, let's say around 3 to 4 marks, you do get a question from here. So, and out of those questions, alteration of MOA is a very popular examination question. We'll take each of the clauses one by one. My very first discussion is about the name clause. So in case you want to alter the name clause, what are the steps that you have to follow? See, the name clause obviously contains the name of the company. If you want to change the name of the company, step number one, you have to pass a special resolution. All right, step number one, call a meeting of the shareholders, pass a special resolution. Step number two, you have to fill an application and get central government's approval also. Step number three, the company has to go to the ROC and file with the ROC both the special resolution and the central government approval. Both of these have to be filed with the ROC. All right, then step number four, the ROC will make a note of this. That is, in the ROC maintains a register of companies, right? So in the register of companies, the ROC will make a note of it. ROC will write the new name of the company in this register, and then ROC will give to the company a new certificate of incorporation which contains the new name of the company. Now, this new name of the company will be effective only on the date on which the ROC gives the company this new certificate of incorporation. This new name will be effective only on the date on which the ROC gives to the company this new certificate of incorporation. Then whatever is a new name of the company, we should put the new name of the company everywhere as in the MOA, in the AOA, in the common seal, on the name board, on the letter pad, everywhere, wherever the company's old name is appearing, we have to change it. We have to put the new name of the company instead. All right, so these are the 5 steps that you have to follow if you want to alter the name clause. First of all, you get a special resolution. Number 2, you get a central government approval. Number 3, the company has to file special resolution and central government approval with the ROC. Number 4, ROC will then put the new name of the company into the register of companies, and ROC will give to the company a new certificate of incorporation containing the new name of the company. We will see when did the ROC give the new certificate of incorporation. On that date, the new name is going to be effective. Then everywhere, wherever the old name of the company is existing, like in the MOA, in the AOA, in the common seal, everywhere we have to remove the old name and put the new name. These are the 5 steps that we have to follow. Okay, now listen to some extra points. Just because I'm changing the name of the company's rights, the company's obligations will not get affected. Just because I'm changing the name of the company, the legal proceedings, nothing but the cases which are going on against the company will not get affected. You will not treat as if old company has come to an end, as if new company is created. It is not like that. The same company is continuing, just with a different name. It is not like old company has come to an end and in its place new company is created. It is not like that. Same company is continuing, just with a different name. All right, then in case the company has any default relating to annual return, or if it has any default relating to financial statements, or if it has any default relating to deposits, if this default is still existing, I will not let the company alter the name. You please rectify the default, only then you can alter the name. If this default is existing, I will not let the company alter the name. Understood this, guys? And one last extra point, in case the only change I am making is I am adding the word private or I am removing the word private. For example, if I want to convert a public company into a private company, I will add the word private. If I want to convert a private company into public company, I will remove the word private. So if the only change in the name of the company is adding or removing this word private from the company's name, in that case I don't need central government approval. The central government approval is not required if the only change is adding or removing the word private. When will I add or remove the word private? If I'm converting the public company into private company and vice versa. If that is the only change, adding and removing the word private, if that is the only change, then central government approval is not required. Understood, guys? So this is my entire discussion with you regarding the name clause alteration. Perfect. So talking about the alteration of MOA, our very first discussion over here was regarding name clause. So if I want to change the name of the company, I will first pass a special resolution and then I will get central government approval. The company will file the special resolution and the central government approval with the ROC. Then the ROC will make a note of the new name in the register of companies, and ROC will give to the company a new certificate of incorporation containing the new name of the company. We will see when did the ROC give to the company the new certificate of incorporation. On that day, the new name will be effective. Finally, we learned on all the MOA, AOA copies, on the common seal of the company, on the letter board of the company, the name board outside the office. Everywhere we have to change the old name. We have to put the new name into the. We have to put the new name in all these places. Then we learned finally, if I am going to change the name of the company, the rights and obligations of the company will not get affected. The legal proceedings will not get affected. Also, I will not treat as if old company has come to an end and new company is created. No, same company is continuing, just with a different name. Then finally, we learned if any default is existing relating to annual return or financial statements or deposits, until this default is existing, we will not let the company alter the name. Company first rectify the default, only then you can alter the name. Okay, then we learned finally that in case the company, if the only change in the company's name is adding or removing the word private, in that case, central government approval is not required. So this was our entire discussion regarding the change of name of the company. All right, now listen to the next point. By the way, listen guys, there is one more connected concept. Do you remember learning that in case I change the company's name, I am supposed to put the old name also in all the places for a certain period? Do you remember learning that? For how long it has to be put? I'll repeat again. If you change the company's name, you have to continue to put the old name also in all places. Along with the new name, you have to put the old name also in all places for how long? For at least 2 years. This concept comes under labeling of company, under that heading, labeling of company's name. Under that heading, this concept comes. So where, like for example, on the name board and all, we will write the new name, and in brackets we will write the old name also for at least the next 2 years. This was just a connected concept. Okay, now I'm taking you to the next discussion. What if I want to change the situation clause? Now, can you tell me first of all, what is the other name of situation clause? What is it also called? The situation clause is also called the domicile clause. Okay, now what do we write in the situation clause? What do we write in the domicile clause? We write over here not the address. We don't write the full address. We just write the state, the name of the state where the registered office is situated. We just write the name of the state where the registered office is situated. Now, if I want to make any change in the registered office, then what's a process I have to follow? Here I have some scenarios. In my first scenario, we are changing the registered office from one area to another area, but we are staying within the same city. For example, we are staying within Mumbai itself, but in Mumbai from Andheri East, let us say we are moving to Andheri West. So we are staying within the same city, we are just changing areas. If you want to do this, then you just need a board resolution, all right? And you have to inform the ROC about it within 30 days. Now, if you're only going to change the area, you're going to stay within the same city, you're going to stay within the same state. In this situation, the situation clause will not have any alteration, because even earlier, the situation clause would have said Maharashtra. Even now, it's going to say Maharashtra only. You're not changing the state. So here there is going to be no alteration in the situation clause, because you're just changing the area. You're staying within the same city. So there will be no alteration of the situation clause. You just need a board resolution over here, and you have to inform ROC about the board resolution within 30 days. Okay. Then talking about my second situation, here you're moving from one city to another city, you're moving, but you are staying within the same state. For example, you're staying within Kerala only, but from Kochi, let us say you're moving to Calicut. So here you're moving from one city to another city, but you're staying within the same state. Even over here, if you see, there will be no alteration of the MOA, because even earlier the MOA would have said Kerala. Even now in the situation clause, we will say Kerala only. There is no change in the state. Now, if you want to change from one area to another area, I said you need just a board resolution, then inform ROC within 30 days. But if you want to change from one city to another city, board resolution you anyways need. In addition to that, you also have to get a special resolution. Then you have to inform the ROC about it within 30 days. Inform the ROC about it. All right. This was my second situation. Then in my third situation, by the way, my third situation is possible only in the states of Tamil Nadu and Maharashtra. See, generally it is understood that generally every state has one ROC only, but only the state of Tamil Nadu and Maharashtra, we have two ROCs each. Like Tamil Nadu has an ROC in Chennai and in Coimbatore, and Maharashtra has an ROC in Bombay and in Pune. So in these two states alone, the third situation is possible. In the third situation, what happens is I am moving from one city to another city, but I am staying within the same state, but the ROC is changing. This is possible only in Tamil Nadu and Maharashtra. For example, I am moving from Pune to Mumbai, or I am moving from Chennai to Coimbatore. I am moving the registered office from one city to another city. I am staying within the same state. Even earlier I was in Maharashtra, even now I am in Maharashtra, but still the ROC is changing. How come? Because in Tamil Nadu and in Maharashtra, I have two ROCs each. So how do you do this sort of a change? In this case also, you need a special resolution first of all. And even before special resolution, obviously you first of all need a board resolution. Then you have to pass a special resolution. Once you pass a special resolution, the company has to make an application to the regional director. We also need the regional director's permission. Okay, regional director will give permission to the company. He will give approval to the company. Within maximum 30 days, he will give his approval. Once a regional director gives approval, company will then file a copy of the regional director's approval with the ROC. Company will inform the ROC about it within 60 days. Both the ROC, the Pune ROC and the Mumbai ROC, company will inform both the ROC within 60 days. Then what will happen is that the new ROC that is the Mumbai ROC will give to the company a new certificate of incorporation. All right, and this new certificate of incorporation will come within 30 days. All right, so the new ROC, the Mumbai ROC, will give to the company a new certificate of incorporation within 30 days. And from the date on which this new certificate of incorporation came, from this date only the change is going to be effective. So here, if you see, there will be an alteration of MOA. In the MOA earlier, it would have been written Maharashtra Pune, but now it will be written as Maharashtra Mumbai. So here, yes, there will be an alteration of MOA. Understanding. So under alteration of situation clause, we're talking about 4 situations. In the first situation, I was staying within the same city, within the same state, same ROC. I just changed one area to another area. In the second situation, I changed from one city to another city, but I stayed within the same state. I also stayed within the same ROC. The third situation is possible only in Tamil Nadu and Maharashtra, because only in these two states you have 2 ROCs each. So here what happens is I'm moving from one city to another city, but I'm staying within the same state, but ROC is changing. Like from Pune, I'm moving to Mumbai, or from Chennai, I'm moving to Coimbatore. I'm staying within the same state, but the ROC is changing. To do this, I need a board resolution first. Then I have to pass a special resolution. Then company has to make an application to the regional director. Regional director will give approval within 30 days. Then company has to file a copy of the regional director's approval with the ROC within 60 days. With which ROC? With both the ROCs, the old ROC as well as the new ROC. We're understanding, guys. Then we learned finally the new ROC will give to the company a new certificate of incorporation. The new certificate of incorporation will be given within 30 days. We will see when did we get this new certificate of incorporation. From that day only, the change is going to be effective. Okay, and then we have one last situation under the change of a situation clause. In the alteration of situation clause, we have one last situation, and that is what if I change my registered office from one state to another state. For example, what if I move my registered office, for example, from Kochi to Kolkata? So here I was earlier under the state of Kerala, and now I'm moving to West Bengal. I'm changing the state itself. Obviously, there will be alteration of MOA over here. Earlier, the MOA would have said Kerala, but now I have to alter it into West Bengal. So here there will be alteration of MOA. Now, if you want to alter the MOA in such a situation, if you're moving from one state to another state, here the process is a little lengthy. First of all, of course, you need to pass a board resolution resolution, then you need to get special resolution even over here. Then the company has to file an application to the central government because we need central government approval also. The central government will give approval to the company within maximum 60 days. The central government will give approval to the company. All right. Then what the company will do is the company will file a copy of the central government's order with both the ROCs, the Kerala ROC as well as the West Bengal ROC. With the old ROC as well as the new ROC, the company will file a copy of the central government's order. Then then the old ROC, that is the Kerala ROC, will shift all the documents relating to this company to the new ROC. So in my example, the Kerala ROC will send all the documents relating to this company to the West Bengal ROC. All right. Then after this, after all this is done, the new ROC, who is my new ROC, guys? The West Bengal ROC will now give to the company a new certificate of incorporation. This new certificate of incorporation, we have to see on which date we got it. From that date only, it's going to be effective. Now, if I want to change my registered office from one state to another state, if I want to do this sort of a change, then I also need the consent of the creditors. I also need the consent of the debenture holders. Only if my creditors, debenture holders, if all of them have consented, only then the central government will give approval. If the creditors and debenture holders are not okay with this change, then central government will not give approval. Understanding. In case the creditors and debenture holders are, let us say, they are dissenting. Dissenting means what? If they are not okay with the change, then we either have to repay them, or we have to give them some security, or we have to somehow get their consent. Only then central government will give approval. Otherwise, if they are dissenting, then central government will not give any approval. See, no doubt in this entire discussion, in a lot of places, a delegation has happened. Like, for example, over here, the central government has delegated the power to regional directors. So, the delegations are not very important from the examination perspective, because in a lot of places, you have a lot of delegations. All right. According to me, it should be sufficient if you just learn the fact that central government's approval is required over here. All right. The delegations are not required, not very important from the examination perspective. So, giving you a quick revision of the entire discussion regarding alteration of situation clause, here we saw 4 situations. In the first situation, I'm changing from one area to another area, but I'm staying within the same city. I'm also staying within the same state, same ROC. Here, I just need a board resolution, and then I have to inform ROC within 30 days. End of story. In my second situation, I'm moving from one city to another city. Like from Kochi, I'm moving to Calicut, but I'm staying within the same state. I'm also staying within the same ROC. Here, I need a board resolution, special resolution, and I have to inform ROC within 30 days. Then, in the third situation, I am moving from one city to another city, but I am staying within the same state, but the ROC is changing. Even though I'm staying within the same state, the ROC is changing. This is possible only in Tamil Nadu and Maharashtra. Here, I have to get board resolution first, then I have to pass a special resolution, then we have to make an application to the regional director, get the approval of the regional director within 30 days. He will give approval within 30 days. Then company will file a copy of the regional director's approval with the ROC within 60 days. Then the new ROC will give to the company a new certificate of incorporation within 30 days. We will see when did we get this new certificate of incorporation. All right. But whenever we get this new certificate of incorporation, from that day, the change of the registered office will be effective. So 30, 60, 30. Easy to remember. The regional director will give approval within 30 days. Then we have to file the regional director's approval with the ROC within 60 days. And ROC will give us a new certificate of incorporation within 30 days. Will you remember this, guys? 30, 60, 30. Okay. Then in the last situation, we learned, what if I move my registered office from one state to another state? What if I what if I change my registered office from Kochi to Kolkata, from Kerala to West Bengal, from one state to another state? In that case, I need a board resolution, I need special resolution, then I have to make an application to the central government. Now, the central government will give me approval only if my creditors and debenture holders are okay with the change. If the creditors and debenture holders, if they are not okay with the change, then either I have to give them some security, or I have to discharge them, I have to repay them, or I have to somehow get their consent. Only then the the central government will give me approval, and central government will give me approval within 60 days itself. Once all this is done, the company will file a copy of the central government's order with the ROC. With which ROC? With both the ROCs. Then the old ROC will send all the documents relating to the company to the new ROC, and then the new ROC will give to the company a new certificate of incorporation. Again, the same thing, we will see when did we get the new certificate of incorporation. From that day only, the change is going to be effective. Is this still clear, guys? So this was my discussion regarding alteration of situation clause. Then coming to the third point under alteration, what if I want to alter the objects clause? The objects clause is the most important clause of the MOA, because the objects clause contains the object of the company, that what are the powers of the company, what are the businesses that the company is going to do. It contains the powers of the company. It is the most important clause of the MOA. If the company wants to alter the objects clause, here it has to pass a special resolution. Then after that, the company will have to file with the ROC a copy of the special resolution. We have to file with the ROC. Then ROC will make a note of this. ROC will register this. ROC will certify this. That is, ROC will give a certificate relating to this within 30 days. And whenever the ROC gives the certificate, from this date only, the change is going to be effective. This is pretty simple. We have to pass a special resolution. Then the company has to inform ROC. ROC will certify this change within 30 days. And once the ROC certifies the change, only then the change is going to be effective. Okay. Now, apart from the objects clause, see, we have already seen three clauses. What are the three clauses? The name clause. Then we saw the situation clause. Then we saw the objects clause. In addition to this, what are the other clauses in the company's MOA? We also have the capital clause. Then we have the liability clause, and then we have the association clause, which is also called as the subscription clause. Now, if you look at the capital clause, alteration of capital clause is going to be covered under the share capital chapter. So in the share capital chapter, when I reach that chapter, there I will help you revise alteration of capital clause, section 61. We will take this in the share capital chapter. So this I'm keeping pending. Now, what about alteration of liability clause? See, in the liability clause, I only write the liability of the shareholders, whether it is limited liability, whether it is unlimited liability, or if it is a guarantee company, then what is the guarantee amount? I only write the liability of the shareholders over here. See, obviously, that's not going to undergo a change. So here there is no question of alteration. The liability of shareholders is not going to undergo a change. So here there is no question of alteration. And lastly, we have the association clause, which is also called as the subscription clause. Now, association clause, subscription clause, what does it contain? It only contains the signature of the subscribers. It only contains the signature of the persons who, it only contains the subscriber signatures, their name, their address, their occupation, how many shares have they taken up, only that it contains. So even over here, there is no scope of any amendment. There's no scope of any alteration. So we have learned about alteration of these three clauses. Capital clause alteration we will be seeing under section 61 share capital chapter, and these two clauses there is no scope of any alteration. Did you understand this, guys? So with this, we're done learning with a third concept relating to alteration of MOA. Guys, if we're learning about alteration of MOA, shall we spend 2 minutes and finish off altering the AOA also? Yes, let us finish it within this concept itself. So here, first of all, we learned about alteration of name clause. Let me call this the first part. In the first part, we learned about altering the name clause, altering the situation clause, and altering the objects clause. In the second part, what if I want to alter the AOA? Then what is the process that I have to follow? If I want to alter the AOA, even over here, I have to pass a special resolution. Then we have to file a copy of the altered AOA. We have to file a copy of the altered AOA with the ROC. See, generally when we file things with the ROC, the period is 30 days. But here we have to file with the ROC within 15 days itself. And then the ROC will make note of it. ROC will register this change, and then thereafter on every copy of the AOA, the company has to put this change. This change has to be reflected in every copy of the AOA. That's it. We have to pass a special resolution. We have to file a copy of the altered AOA with the ROC within 15 days. ROC will register this change, and hereafter on every copy of the AOA, this change has to be reflected. We always have to make sure that this change is not against the MOA. This change should not be against the Companies Act. This change should not be against some fourth order. This change should not be illegal. This change should not be against public policy. This change should always be bona fide. That is, it should be in the best interest of the company. Still clear with this? Yes, one last revision. This change should not be against the MOA. It should not be against the Companies Act. It should not be against the court order. It should not be illegal. It should be bona fide, and it should be in the best interest of the company as a whole. So this was my discussion with you regarding alteration. My third concept of revision, we spoke about alteration of name clause. In name clause alteration, main points, I need special resolution and I need central government approval. Special resolution and central government approval. Okay. Then we spoke about alteration of situation clause. Under the alteration of situation clause, we saw 4 different situations. In changing just the area, I need just the board resolution. If I'm changing the area, if I'm changing the city itself, but I'm staying within the same state, I also need a special resolution. If I am changing from one city to another city and I'm even changing the ROC, staying within the same state, there I need special resolution and also RD approval. But if I'm changing from one state to another state, I need special resolution. I also need central government approval. Understood, guys? And finally, we learned if you want to alter the objects clause, here we just need a special resolution. Okay, so with this, shall we close our discussion relating to the third concept, alteration of MOA? Along with this, we have also learned about alteration of AOA. Okay, now let me take you to the next discussion, which is about rectification of company's name. This is extremely important concept from the examination perspective, rectification of the company's name. Here the central government plays a role. If the central government thinks it is required, the central government can ask the company to change the company's name. All right. So we're going to be learning the process relating to that. So my fourth concept, rectification of company's name. Here it will be nice if you can remember the section number. What's the section number over here? Section 16, rectification of company's name. Now listen to me. Let me give you a revision of this concept. See, when will the central government have a problem? When will the central government ask you to change your company's name? In 2 situations. Situation number 1, the company is already incorporated and the company's name is very identical to the name of another existing company. Or the company's name is identical to the name of another existing registered trademark. So either the company's name is similar to the name of another existing company or it is similar to another existing registered trademark. Okay. So in such a case, the central government will pass an order asking the company that company, come on, change your name. Now listen guys, just now we had learned to change the company's name. What kind of resolution do we need? Tell me. To change the company's name, we need a special resolution, guys. But here, to change the company's name, central government will ask the company to change its name simply by passing an ordinary resolution itself. So the central government is asking the company to change the name. Just an ordinary resolution itself will be enough. Now, if you're talking about delegation, even over here, the central government has delegated the power to the regional director. But delegations are something which I'm not paying too much attention on. Okay, so coming back to my discussion, the central government will pass an order asking the company to change the name simply by passing an ordinary resolution, and this change has to be done within the period of 3 months itself. All right, guys. Now listen to me. In case the company's name is similar to the name of another registered trademark, here don't forget to write the word registered. See, like how I told you, you write the word stock exchange, you might lose marks. What should you write? Recognized stock exchange. Similarly, this word registered has huge significance. You have to say it should be similar to the name of another registered trademark. If you just write trademark, you may lose some marks because this is a keyword over here. So I'm talking a little bit about this point. In case the company's name is similar to the name of the registered trademark, here the central government will pass order only if the proprietor of the trademark, that is the owner of the trademark, should have complained to the central government within 3 years from the date of incorporation of this company. My company is incorporated, guys. My company's name is similar to the name of another registered trademark. For example, Paytm is a trademark of 197 Communications Limited. So if I start another company with the name Paytm Limited, my company's name is similar to the name of another registered trademark. So in that case, the owner of the trademark should complain to the central government. They should file an application to the central government within 3 years from the date on which I incorporated the company with the same Paytm word. Understanding. So but then this 3 years criteria and all is not there for this existing if the company's name is similar to company's name, there you don't have this criteria. But this criteria is only when the company's name is similar to the name of another existing registered trademark. Understanding. So once again, if the company's name is similar to the name of another existing company, or if the company's name is similar to another existing registered trademark, then the central government will pass an order asking the company to change the company's name within 3 months simply by passing one ordinary resolution. Okay. But if the company's name happens to be similar to the name of another existing registered trademark, central government will take action only if the owner of the trademark has filed an application with the central government within 3 years from the date of incorporation of the company. Till here, did you understand, guys? Yes, then after all of this, after this order is passed, what will the company do? The company will change the name. Okay, after changing the name, the company has to inform ROC about it. All right, after the company changes the name, company will give a notice to the ROC and the company will inform the ROC about the name change. Now, company will give to the ROC two things. Number one, company will give to the ROC notice of the change, means informing the ROC about the change. And number two, company will also give to the ROC a copy of central government order. This order asking the company to change the name. So we will give this notice of change along with central government's order. Now listen, generally whenever we file anything with the ROC, what number of days do you talk about? What period of days do you talk about? You talk about 30 days, right? But we just spoke about 15 days. Where did we talk about 15 days? Try to recall and tell me. Alteration of AOA, we said the period is 15 days, guys. Everywhere else we have spoken about 30 days only. Only under alteration of AOA, we said we have to inform ROC within 15 days, right? Now, even over here, the period is 15 days. So we have to inform ROC about it. We have to give notice of change to the ROC. We have to file a copy of the central government's ROC with the ROC within 15 days of change. So once we change the name from that day, within 15 days, we have to file these two things with the ROC. Okay, then after that, what will the ROC do, guys? The ROC will make the necessary changes in the certificate of incorporation of the company. The ROC will make the necessary changes in the MOA of the company and all. So all this is the process that has to be followed under section 16. So here the central government has asked the company to change the name. So therefore the company has changed the name. But guys, don't you think there is a possibility that even though the central government is asking the company to change the name, the company is not changing the name? The company is defaulting. There is a possibility, right, that even though the central government has passed an order asking the company, come on, change the name, but the company is not changing its name. So if the company does not change its name, in that case, what will you do? If the company does not change the name, in that case, the central government itself will change the name of the company. And the central government will not think of some nice name and all. The central government will change the name of the company into ORDNC, which means Order of Regional Director Not Complied. Order of Regional Director Not Complied. By Regional Director, remember I was telling you, central government has delegated this work to the Regional Director. So in reality, it's actually the regional director who's going to order the company to change the name. So the central government will change the company's name into ORDNC, which stands for Order of Regional Director Not Complied. Then the year in which the order was passed, let us say the order was passed in the year 2022, then a serial number, let us say serial number of the order, and lastly the CIN of the company, whatever is a CIN of the company, this will this will become the new name of the company. All right, ORDNC, year, serial number, and CIN, private limited or limited as the case may be, this will become the new name of the company. All right, then once the central government changes the name of the company, the ROC will enter the new name of the company into the register of companies, and then the ROC will give to the company a new certificate of incorporation containing this fancy name. All right, guys. Then wherever the company's name is affixed, like for example on the name board, on the letter pad of the company, wherever the company's name is put, in all those places we have to write order of regional director not complied. Wherever the company's name is published, on the name board, on the letter board, everywhere we have to mention order of regional director not complied with. After doing this, if the company wants, yes, the company can change the name, because obviously this will be a very embarrassing name for the company. So the company can change the name, but if the company wants to change the name, now how will the company change? Now, if the company wants to change the name, it will have to change the name by following this process. That is, it will need a special resolution. If it had listened to the central government, if it had followed the central government's order by passing ordinary resolution itself, it would have been able to change the name. But it did not follow the central government's order, so the central government itself changed the name of the company. Now, if the company wants, company can change this dirty name into something nicer. But if the company wants to do that, then it has to follow the entire process of altering the name clause. That is special resolution, central government approval, all those steps it has to follow. This is section 16. Understanding. So section 16, I'm giving you a full revision of section 16. Once again, guys, please listen to me carefully. This is extremely important from the examination perspective. What are we talking about? Rectification of the company's name. The company is already incorporated. We all know that the company's name should not be identical or similar to the name of another existing company. It should not be identical or similar to the name of another existing registered trademark. If it is similar to the name of another existing company, or if it is similar to the name of another registered trademark, then the central government will ask the company to change the name within 3 months by simply passing one ordinary resolution. If the name is similar to the registered trademark, here central government will take action only if the owner of the trademark, the proprietor of the trademark, files an application with the central government within 3 years from the date of incorporation of this company. Then we learned once the company changes the name, company will send to the ROC how many things? Company will send to the ROC 2 things. Number 1, a notice of the change informing the ROC that I have changed the name, and number 2, a copy of the central government's order. Both of these have to be sent to the ROC within 15 days of changing the name. Then the ROC will make a note of this in the certificate of incorporation as well as in the MOA. Then we learned in case the company doesn't follow the order of the central government, that is, even though the central government has passed the order, what if the company doesn't change the name within 3 months? In that case, central government itself will change the name of the company, and that name will be ORDNC, which stands for Order of Regional Director Not Complied, then year in which the order is passed, then the serial number of the order, then the corporate identification number of the company, private limited or limited as a case may be. This will become the new name of the company. ROC will make an entry of the new name in the register, and ROC will give to the company a new certificate of incorporation containing this new name. Wherever the company's name is affixed, like outside the company's office, in the name board, in the letter pad and all, wherever the company's name is put, in all those places we have to write in brackets that order of regional director not complied with under section 16, order of regional director not complied with. We have to write this everywhere. Then we learned that after this, if the company obviously will be feeling embarrassed because of this name, now if the company wants to change the name, yes, the company can change its name, but now if it wants to change the name, it has to follow the entire process of altering the name clause. That is special resolution, central government approval, all that entire process it has to follow. Got it, guys? So with this, we have learned about rectification of company's name. What was the section number over here, guys? Section number 16. Crystal clear with this discussion, everybody? Yes. Now, listen, guys. This now that we're learning about this concept, there is one more similar concept, okay, which you should not get confused about. So let me discuss that with you here itself. It is not a part of section 16. Section 16 is over, but there is one more a slightly similar concept. There, ROC is asking the company to change the name. Here, what did we learn under section 16? Who is asking the company to change the name? Here, central government is asking the company to change the name, right? But there is one more concept, okay, where ROC is asking the company to change the name. It is not a part of section 16. Just that I don't want you to mix both the concepts up. That is why I want to spend 2-3 minutes and discuss that also for you. Listen to me. The situation goes like this. Let us say name reservation is done. See, for incorporation of the company, we have to do name reservation, right? Which is valid for 20 days. So name reservation is done. But that name reservation was done by filing wrong information, or that name reservation was done by filing incorrect information. By filing wrong information, by filing incorrect information, the company got name reservation done. After name reservation, ROC is realizing this. Understanding, ROC has done the name reservation. After that, ROC is realizing, oh God, for name reservation, the documents and all which they filed, it contains wrong information, it contains incorrect information. After name reservation only, ROC is realizing this. Now ROC will check, is the company already incorporated or is the company not incorporated? See, if company is not incorporated, very simple. In that case, ROC will simply cancel the name reservation and ROC will ask the promoters and all to start afresh. ROC will say your name reservation was done by submitting wrong information. I am cancelling the name reservation. Now you restart the entire name reservation process, you start again afresh. And whoever is involved over here, whoever is the person who made the application, the person who submitted the application containing all this wrong information, we will punish this person with a fine of up to 1 lakh rupees. We will punish him. Okay, but what if the company is already incorporated? If the company is already incorporated, in that case, first, obviously, we will give opportunity of being heard. Obviously, we will give opportunity of being heard to the company. And then after that, ROC will pass an order. Now, what order will ROC pass? Either ROC will ask the company, come on, change the name. Change the name within 3 months by passing ordinary resolution. Same thing like what we saw under section 16. Or ROC will simply strike off the company's name from the register of companies. See, you should understand a company exists only till its name exists in the register of companies. From the register of companies, once I remove the name, then the company doesn't exist anymore. Understanding. So ROC can simply strike off the company's name from the register. And number 3, ROC may pass an order for winding up of the company. Out of the 3, any one of the 3 orders, the ROC can pass. Did you understand this, guys? Yes. So in case we talk about, rectification of name, you will write about this concept. When will you write about this concept? This concept is called as cancelling the name. You are understanding section 16 rectification. Okay, there you will write about central government is asking the company to rectify the name. Then if they talk about cancelling the name, there you will not write section 16. Cancelling the name, you will write about this concept. This is called cancellation of name. That was section 16. It's called rectification of company's name. Perfect understanding, everybody. Yes, if the ROC has already done name reservation, after doing name reservation, ROC is realizing that in the form that you submitted wrong information, incorrect information. So ROC will check, is the company already incorporated or is the company not incorporated till now? If it is not incorporated till now, ROC will simply cancel the name reservation, and whoever had submitted this application containing wrong information, we will punish them with a penalty of up to rupees 1 lakh. But in case company is already incorporated by submitting wrong information and all, we will first give the company an opportunity of being heard, and then ROC will pass an order asking the company to change the name within 3 months by passing ordinary resolution, or we will strike off the company's name from the register, or we will pass an order for winding up of the company. Crystal clear with this concept, guys? So can we close the first 4 concepts? Everybody, please give me some response. Yes, still here. Are you confident? Yes, we first spoke about listed, unlisted companies and small companies. Then we spoke about section 10A. Then along with alteration of MOA, we also had a discussion regarding alteration of AOA. And then we learned about rectification of company's name. And along with this, we also learned about cancelling the company's name. All right, guys. Now I'm taking you to the next discussion. We're going to be learning about the doctrine of indoor management along with its exceptions. All right. Now, you know very well that there are totally three doctrines as a part of your syllabus. You have the doctrine of ultra-virus, you have the doctrine of constructive notice, and you have the doctrine of indoor management. So we are going to be discussing right now the fifth discussion. We're going to be learning about the doctrine of indoor management, and then we'll be learning about the exceptions. But before we learn about doctrine of indoor management, let us discuss about the doctrine of constructive notice also. Okay, so that you're able to connect a little better. Now, doctrine of constructive notice, tell me, it puts full responsibility on whom, guys? It puts full responsibility on the outsider. It tells the outsider that outsider, listen, you read the AOA. You identify what are all the points in the AOA which are applicable to your contract with the company. Outsider, you ensure that the company complies with the AOA. Because later, if we find that the AOA is not being complied with, in that case, the contract will become void. Now, can the outsider say that I did not know what is written in the AOA? Outsider, you cannot say that because the MOA and the AOA are public documents. So we will assume that the whole world knows about it. So you, outsider, listen, before you enter into a contract with the company, you have to first of all take the company's AOA, read the company's AOA, identify which point in the AOA will apply to your contract with the company, and you make sure that the company is following all those points. Because later, if we find out that the company has not followed the AOA, then your contract will be void. So this particular doctrine was putting full responsibility on the outsider, and it was nicely protecting the company. And because of this doctrine, it was becoming impossible and very, very difficult to do business with the company. That is why in the case of Royal British Bank versus Turcond. In this case, for the very first time, the court said we will not apply the doctrine of constructive notice. Instead, we will apply the doctrine of indoor management hereafter. Now, what exactly happened in the case of Royal British Bank versus Turcond? Listen to me. There was this company, Royal British Bank Limited. Okay. Now, in this company's AOA, it was clearly written that the directors can borrow money on behalf of the company. But if they want to borrow money on behalf of the company, before that, they need to get a shareholders resolution. They need to call a general meeting of the shareholders, and they need to get a shareholders resolution, basically an ordinary resolution or a special resolution, whatever. Pass that resolution, only then the directors can borrow money on behalf of the company. Now, what the directors of the company did was, the directors of the company, they borrowed a loan from this particular lender. They borrowed the loan without passing any shareholders resolution. They borrowed this loan, and later they refused to repay, saying that the loan is void. Okay, when this lender said, why is this loan void? The company said that my AOA is not being followed. AOA says shareholders resolution is required, but we did not pass any shareholders resolution before borrowing loan from you. Therefore, our AOA is not being followed. Therefore, your loan is void. This lender couldn't understand this. The lender said, your AOA, you did not follow. Why are you punishing me? Why are you calling it void? The company obviously spoke about the doctrine of constructive notice and all. This lender, this Mr. Turcond, he went to the court. He complained about this to the court, and when he complained about this to the court said, enough is enough, no more doctrine of constructive notice. Instead, we will apply the doctrine of indoor management hereafter. Now, what does the doctrine of indoor management say? The doctrine of indoor management protects whom? It protects the outsider. The doctrine of indoor management tells the outsider that you can assume that all the internal rules and regulations are being followed. You can assume. What does the doctrine of indoor management say? Outsider, you can assume that the company is following all the internal rules and regulations. You can assume. You don't have to, spend time and effort reading the AOA and checking whether company is following internal rules or not. You don't have to put in any extra effort. You can assume that the company has fulfilled all the internal rules. Later, if we find that the internal rules given in the AOA are not being fulfilled, it's okay. The contract will still remain valid only. The outsider will not get affected. You're understanding, guys? The doctrine of constructive notice put full responsibility on the outsider. It told outsider, you check that company is following its AOA. If AOA is not being followed, then the contract itself will become void. But in the case of Royal British Bank versus Turcond, the court said we will not apply the doctrine of constructive notice anymore. We told Mr. Turcond, we told the outsider that you can assume that the internal rules and regulations are being followed. That is, you can assume that the articles of association is being followed. All right, we will assume that all the internal procedures have been followed by the company. Later, if we get to know that the AOA is not being followed, the outsider should not get affected. The contract of the outsider should still remain perfectly valid. Okay, but there are some exceptional cases where I cannot apply the doctrine of indoor management, which means in those exceptional cases, I will still apply what? I will still apply the doctrine of constructive notice. Okay, now what are these exceptional cases? There are totally 3 exceptional cases. In the first exceptional case, the outsider was already aware of the irregularity. The outsider was already aware of the irregularity. He was already aware of the irregularity, which means he already knew that the internal rules are not being followed. See, listen, you can assume something only when you don't know the reality. When you know very well internal rules are not being followed, how can you assume that internal rules are being followed? You're understanding the logic. When you know very well that the internal rules are not being followed, then how can you assume that internal rules are being followed? So that was my very first exception in the case of Howard versus Patent Ivory Company. Howard versus Patent Ivory Company. So what exactly happened in this case was, see, I'll just give you a quick summary of this case. In this situation, in this case, there was this company, let us say, Patent Ivory Company Limited, P Limited, let us say. Now, in this company's AOA, it was written that the company can borrow, it can borrow money, but at the maximum, it can borrow, let us say, 5 lakh rupees. This is the maximum amount what it can borrow. Now, this company had 2 directors, director 1 and director number 2. Now, director 1 gave a loan to the company, a loan of 7 lakh rupees. Now, this is definitely going to be, it will get caught. It will get caught under this exception, because see, who is giving the loan to the company? Director. Now, the director will obviously know about the internal rules of the company. How can the director say, I did not know what is written in the AOA? AOA says maximum 5 lakhs, but director is giving a loan of 7 lakhs. The director will obviously know what is written in the AOA of the company, guys. So the director is aware of the irregularity. He knows that the company is doing something which is against the AOA. Company is borrowing a loan of 7 lakh rupees, whereas company can borrow maximum only 5 lakh rupees. So when he already knows about the irregularity, in that case, he cannot take protection against the doctrine of indoor management. Here, director 1 cannot say that I thought internal rules are being followed. Director 1, you can assume like that only if you did not know about the internal rules. You are the director. Obviously, you will know about the internal rules. Obviously, you know very well that the internal rules are not being followed. When you know that the internal rules are not being followed, how can you assume that internal rules are being followed? So if the outsider was already aware of the irregularity, we will not protect the outsider. If we don't protect the outsider, obviously, which doctrine are we applying there? We are applying the doctrine of constructive notice. Understood, everybody? Yes. So this was my first exception. Okay, now listen to my second exception. In the second exception, there is negligence. In the second exception, there is pure carelessness. Listen, outsider, no doubt we will protect you. See, the doctrine of indoor management is going to protect the outsider, but we will protect the outsider only if the outsider is showing basic common sense. If the outsider himself is being careless, then we will not protect the outsider. Here we have the case of Anand Behari Lal versus Dean Shaw and Company Bankers Limited. Anand Bihari Lal versus Dean Shaw and Company Bankers Limited. This company D Limited, it owned a piece of land, okay? And this person, Mr. Anand, let us call him Mr. A, he wanted to buy that land from a very long time, but the company did not want to sell away the land. So this company's accountant came to Mr. A and said, we will sell the land to you. But then immediately you have to give us advance. Mr. A immediately gave advance to the accountant because he badly wanted to buy that land. He gave the advance, he is waiting, but that land is not even coming. So in that case, Anand Bihari Lal filed a case against Dean Shaw and Company Bankers Limited saying that you promised me you will sell your land to me. I even gave you advance, but you're not giving your land to me. The court said, listen, Mr. Anand Bihari Lal, the accountant does not have any authority to sell this company's land. Outsider is saying, I will apply doctrine of indoor management. I will assume that the company has given authority to the accountant. The court said, listen, Mr. Anand Bihari Lal, the doctrine of indoor management is on one side, common sense is on the other side. How can an accountant have the authority to sell away a company's land? Don't you think this is fishy? Don't you think you should have put in reasonable inquiry to check whether the accountant actually has the authority or not? So that was a case of that was the second exceptional case, that if the outsider is being careless, if the outsider is not putting reasonable inquiries, a suspicious circumstance is existing, it is very clear that how can an accountant have authority to sell away company's land? See, if MD is in the place of the accountant or the CEO is over here, then still understandable. But how can an accountant, a mere accountant, how can a mere accounting clerk have the authority to sell away company's land? So here, Mr. Anand was simply being careless. When he is going to be careless, we will not protect the outsider. Okay, this was the case of Anand Bihari Lal versus Dean Shaw and Company Bankers Limited. This was my second exception. Then talking about my third exception is about forgery. In my third exceptional case, what happens is there is some forgery in the document. Now, in case there is any forgery, there's a universal rule that forgery is equal to nullity. If there is a forgery, nobody can protect you. Even the doctrine of indoor management cannot protect you. Here also you have a case, you have the case of Rubin versus Great Fingal Consolidated Limited. Rubin versus Great Fingal Consolidated Limited. In this case, what happened is the share certificate contained forged signatures. The managing director of the company, the other two directors of the company, their signature and all was forged by the company secretary. Now here the shareholder cannot say that I will assume all internal rules fulfilled. Shareholder cannot say I will assume that there is no forgery. If there is forgery, it is a nullity. If there is forgery, it is void. Even the doctrine of indoor management cannot protect the outsider. Nothing can protect the outsider against forgery. Forgery means it is void. Okay, here you cannot say I will assume all internal rules and all fulfilled. Forgery means it is void. Got it, guys? So this was my discussion with you regarding the doctrine of indoor management. The doctrine of indoor management is only applicable today. The doctrine of constructive notice is not applicable anymore. Under the doctrine of indoor management, I will protect the outsider. Under the doctrine of indoor management, the outsider can assume that all the internal rules and regulations of the company are being followed. Understanding, guys? But we have three exceptional cases where I still apply the doctrine of constructive notice. Number one, when the outsider was aware of the irregularity, that is, the outsider very well knew what the company is doing is not as per its internal rules. When you know that what the company is doing is not as per internal rules, how can you assume that internal rules are being followed? Are you understanding? When you know very well that the internal rules are not being followed, how can you assume that internal rules are being followed? Second exception was negligence. If the outsider is careless, if a suspicious circumstance is existing, he should put in reasonable inquiries. If he's not putting reasonable inquiries, if he's being careless, then we will not protect him. And third situation if there is forgery, then forgery is equal to nullity. Nothing can protect you from forgery. Even the doctrine of indoor management cannot protect you from forgery. Perfect understanding regarding this, guys? Yes, so this was our discussion regarding the doctrine of indoor management along with the exceptions relating to the doctrine of indoor management. All right, guys, listen. We've spoken about the doctrine of constructive notice. We have spoken about the doctrine of indoor management. Shall we spend 2-3 minutes and finish learning ultravirus also? It is not there in my list of important concepts, but let us finish it off so that your burden becomes a little lesser. The doctrine of ultra virus. Now, the doctrine of ultra virus, what does the word ultra mean? Ultra means beyond, and virus means powers. The doctrine of ultra virus simply says that the company's powers are written there, guys. Simple doctrine. Keep participating along with me. We'll finish it off quickly then. Virus means powers. So where are the company's powers written? The company's powers are written in the MOA. In which clause? In the objects clause. Okay, so the company can do only those things which are written in the MOA in the objects clause. If the company does anything which is beyond the objects clause, if the company does anything which is not written in the objects clause, then it will become void ab initio. It's ultra virus the company. It will become void ab initio. Once it becomes void ab initio, it cannot be ratified even by the whole body of shareholders. Even if every single shareholder is saying let us ratify, it still cannot be ratified. It is void and it will remain void. So if my company does any act, if my company does any act, if it enters into any contract which is against the MOA, against MOA which clause? Against the MOA objects clause. In that case, that contract will become ultra virus the company. That contract will become void ab initio, and the contract cannot be ratified even by the whole body of shareholders. It cannot be ratified. Now listen, what if the company has already spent money on this ultra virus contract? What if the company has already spent money on this ultra virus contract? It is still void ab initio, but the company has spent money, which means company has incurred a loss, guys. Now, so who will be liable for this loss? The directors of the company, they will be personally liable for this loss. Do you remember learning this, guys? Yes. Now, what if the company has not spent money till now? It is about to spend money. It is about to spend money on the ultra virus transaction. In that case, the shareholders can simply go to the court and get dash. Shareholders can go to the court and request for what? They can request for an injunction order. They can request for a stop order stopping the company from spending the money. So if the company has already spent the money on ultra virus transaction, then we can ask the directors to be personally liable for the money. But if the company is about to spend money for the ultra virus transaction, then the shareholders can go to the court and they can ask the court to stop the company. They can ask the court to pass an injunction order, stop the company from spending the money on ultra virus transaction. Now listen, here, can the outsider say, how will I know what is written in the MOA? No, listen, MOA is a public document. Any outsider who is entering into a contract with the company, he should first look at the MOA, check whether the contract is within the powers of the company, only then he should enter into the contract. If the contract is not within the powers of the company, he should not even enter into the contract. If it is not within the powers of the company, and still if he enters into the contract, it will be ultra virus, it will be void ab initio. Now he cannot say, I did not know, it is not within the powers of the company. Listen, outsider, MOA is a public document. You should know what is written in the MOA. You cannot give an excuse later that you did not know what is written in the MOA. Okay, then relating to ultra virus transactions, you have a case law also, guys. What is the case law's name? You have Ashbury Railway Carriage and Iron Company Limited versus Riche. What was the conclusion of this case? Do you remember? In this company's MOA, it was written that the company can do any other contract, general contract. The court said that in the MOA, if you find general contract written, like for example, in this company's MOA, it was written mechanical engineering and general contract. Now the court said general contract does not mean you can do any contract under the sun. General contract will mean you can do only those contracts relating to mechanical engineering. The court said that if we say that general contract includes every contract under the sun, then will any company give the list of businesses in the objects clause? No, then every company will start writing general contracts, or they will write other contracts, or they will put the word etc. And they will say company has a power to do every business under the sun, which will defeat the whole objective of having the objects clause. We want the company to list down the businesses. So if we have any general word like this, the general word will be nothing but contracts relating to whatever is specifically mentioned. So when I say mechanical engineering and general contractors will include only those contracts which are relating to mechanical engineering. Are we crystal clear with this discussion, guys? Yes, so this was our entire discussion regarding the doctrine of ultra virus and the doctrine of indoor management and the doctrine of constructive notice. So, what are the case law names we have spoken about? Royal British Bank versus Turcont. Then we spoke about Howard versus Patent Ivory Company. Howard versus Patent Ivory Company was relating to what? You're aware of the irregularity. Then we spoke about Anand Bihari Lal versus Dean Shaw and Company Bankers Limited. That case law was about what? That case law was about negligence. You are being careless, then doctrine of indoor management will not protect you. Negligence. Okay. Then we learned about Rubin versus Great Fingal Consolidated Limited. What was that case law about? Forgery. Very good. And then relating to the doctrine of ultravirus, even here we learned a contract. Ashbury Railway Carriage and Iron Company Limited versus Riche. Here we learned that in case the MOA objects clause contains a general word like this general word will not include every contract under the sun. This general word will include only those contracts which are relating to whatever is specifically mentioned. Because if we say that the general word will include every contract under the sun, then no company will give list of businesses. If it doesn't give the list of businesses, then the whole purpose of having objective clause will get defeated. All right, guys, are you following this entire discussion? Yes. Is it making it any bit better for you? So going forward now to the next discussion, we're entering the prospectus chapter, and here we're going to take up abridged prospectus, shelf prospectus, and red herring prospectus. All the three we will be discussing one after the other. So first of all, I'm talking to you about abridged prospectus. See, this abridged prospectus, here the key word is that it is a memorandum containing the salient features of the prospectus. That is, it is nothing but a summary of the entire prospectus. This abridged prospectus has to be attached to the share application form, and but then this abridged prospectus is not required in two cases. Number one, it is not required if I am entering into an underwriting agreement. There, to the underwriters, I don't have to give them the abridged prospectus. And number two, I need abridged prospectus only when I'm making a public offer, which means if I am not making a public offer, even over there, abridged prospectus is not required. So simple, abridged prospectus is nothing but a prospectus which is a memorandum containing salient features of the prospectus, which means it is a summary of the entire prospectus, contains the most important points of the prospectus. It is attached to the share application form. And also it is not required if I'm not giving, if I'm giving the shares only to the underwriters, or if I'm not making a public offer, then the average prospectus is not required. Okay, then talking about the shelf prospectus. The shelf prospectus is a prospectus which has validity period of how long? It has validity period of 1 year. So in that 1 year, I can make any number of issues again and again. I do not have to issue a prospectus. The same prospectus itself will apply for all the subsequent issues in that 1 year. But every time I make an issue, at least I have to prepare an information memorandum. This information memorandum will contain changes in the financial position of the company. This information memorandum will contain also any new details about any new charges that are created, and also any other major changes, any other material changes in the company. So a shelf prospectus is a prospectus which has a validity period of 1 year. In that 1 year, any number of issues I can make. I don't have to issue a prospectus again and again, but every time I make a issue, at least I'll have to prepare an information memorandum which contains details about changes in the financial position, details about new charges created, and any other major changes that have happened since the shelf prospectus was issued. But this shelf prospectus cannot be issued by every company. It can be issued only by a specified class of companies. Okay, then this information memorandum, a copy of this information memorandum has to be filed with the ROC also. All right, then listen, in case for all subsequent issues, what will be the prospectus now? For all subsequent issues, the prospectus will be the shelf prospectus plus information memorandum. Then if any person has given advance money for subsequent issues, he has given us advance money now itself. In that case, we cannot adjust this advance straight away against the subsequent issue. We have to give him an opportunity. If he wants to take a refund, we should give him the refund within 15 days. So if he has given us advance money, we cannot straight away adjust the advance money against the subsequent issues. We should give him an opportunity. If he wants to claim a refund, he can claim the refund. So this is about shelf prospectus. it has validity period of 1 year. In that 1 year, every time I issue the securities, again and again, I don't have to prepare prospectus. The same shelf prospectus itself will apply for all subsequent issues. But at least for all subsequent issues, I'll at least have to prepare an information memorandum. Information memorandum is nothing but the document which contains details about all the changes in the financial position, any details about any new charges created, and any other major changes which have happened. This information memorandum, we also have to file this information memorandum with the ROC. Now, when do we have to file it with the ROC? 1 month before making the subsequent issue, we have to file it with the ROC. But this shelf prospectus is not allowed for every company. It is allowed only for some specified classes of companies. For all subsequent issues, prospectus will be both the shelf prospectus plus information memorandum put together. And then we learned that in case any person has given us advance money to be adjusted against subsequent issues, we cannot straight away adjust the advance against subsequent issues. We have to let him know about the information memorandum. We have to let him know about the changes which have happened since the time he gave us advance money. Since then till date, what are all the changes that have happened? We have to give him the information memorandum. We have to give him an opportunity. If he wants to get a refund, we should give him the refund within 15 days. Okay, so this was a discussion regarding shelf prospectus. And then finally, coming to the discussion regarding red herring prospectus. Red herring prospectus is the prospectus which is an incomplete prospectus. It does not contain details about the quantum of securities. It does not contain details about the number of securities. It also does not contain the details of price per security. Here we will just say totally how much money the company wants to raise, but what's the breakup? How many securities? How much price per security? All that we will not write in the red herring prospectus. And then we will see what is the date of opening the subscription list. Before the date of opening the subscription list, leave 3 days. Before 3 days itself, we should file a copy of the red herring prospectus with the ROC. The opening of the subscription list is nothing but the date when the public can start sending share application form. So when can the public start applying for the shares? That is called the date of opening the subscription list. So before the public can start applying for the shares, before that date, leave 3 days. Even before 3 days, a copy of the red herring prospectus we have to file with the ROC. And then once we close the subscription list, once the share application time period is over, now the company will decide the quantum of securities. Company will decide the price per security. Now the company will complete the prospectus. So now the final prospectus, the completed prospectus, even this we have to file with ROC and SEBI. So which means whenever there is a red herring prospectus, there will be 2 prospectus. First of all, there will be the incomplete prospectus, which does not contain information about the number of securities, also doesn't contain information about price per security. Then once the subscription list is closed and all, once the company has decided all this, the company will prepare one more prospectus, which will be the final prospectus, which contains all the details. All the details which were incomplete over here, all those details will be completed in the final prospectus. So all that final completed prospectus also has to be filed with ROC and SEBI. Got it, guys? So this was our discussion regarding abridged prospectus, shelf prospectus, and red herring prospectus. Understood? Abridged prospectus keyword, it is a prospectus which is a memorandum which contains salient features of the prospectus. Then shelf prospectus, we said it has a shelf life of 1 year, but here I have to prepare information memorandum every time. Then red herring prospectus, 2 things are missing: quantum of securities is missing and price per securities is missing. But red herring prospectus I have to file with the ROC at least 3 days before opening the subscription list. I have to file it with the ROC. Crystal clear with this discussion also, guys? So this was our discussion relating to abridged prospectus, shelf prospectus, and red herring prospectus. Okay, next I'm discussing with you about misstatement in prospectus, my next concept. Listen to me. What if there is a misstatement in the prospectus? What will be the implications of a misstatement in the prospectus? Let me discuss this with you. First of all, misstatement means what? Misstatement in the prospectus means that the prospectus has become a misleading prospectus. How did it become a misleading prospectus? Either it contains some incorrect statement, either it contains a misrepresentation, that is, it contains a wrong statement, or it hides important information, which means there is an omission, which means that there is a concealment. Some important fact is being concealed or being hidden from the prospectus. So when there is a misstatement in the prospectus becomes misleading because either I have written a wrong sentence, an incorrect sentence, or I have made some misrepresentation in the prospectus, or I have hidden important information. There is an omission. Now, when there is a misstatement in the prospectus, two sections, two implications arise. What are the two implications? Number one, you have section 34, which talks about criminal liability, and number two, you have section 35, which talks about civil liability. Right now, I'm talking about criminal liability, section 34. Now, criminal liability, if you want to apply this concept, then number one, the precondition is that there must be mens rea. Mens rea means there must be some guilty mind. That is, purposely, you should have put the wrong statement. If you put the wrong statement in the prospectus by mistake, unknowingly, then I cannot punish you under section 34. Section 34 can apply only if you purposely put the wrong statement. That is, there is mens rea. Then if criminal liability section 34 is applicable, we will follow the Criminal Procedure Code 1973. We will follow this. And we will treat as if the company has done an offense against the entire state. We will treat as if the company has done something wrong against the entire society as such. All right. Now, if criminal liability is attracted, what does section 34 say? Section 34 says that, let us say, the prospectus has been ICD. The prospectus has been ICD. Three keywords: prospectus has been issued, prospectus has been circulated, prospectus has been distributed. Again, guys, prospectus is issued, circulated, and distributed, but this prospectus either contains an incorrect statement or this prospectus contains an omission because of which the prospectus has become a misleading prospectus. Now, all those persons who had authorized the issue of prospectus, all of them will be punished. They will be punished under which section, guys? They will be punished under section 447. Now, what is this 447 punishment? It is nothing but imprisonment. How much imprisonment, guys? It is imprisonment of minimum 6 months and maximum 10 years. And number two, we will also punish them with a fraud, with a fine. How much fine? We will punish them with a fine of up to 3 times the amount of fraud which is involved. Okay, imprisonment and fine. Now, 447 is a punishment which you cannot forget. 447 punishment applies wherever there is fraud. Immediately, you can talk about the 447 punishment. What is a 447 punishment? Imprisonment minimum 6 months, maximum 10 years, and fine. Fine, how much? Maximum 3 times the amount of the fraud. So, section 34 says, if the prospectus has been issued, circulated, distributed, guys, hint, ICD, you have to write all the 3 words, okay? Prospectus is issued, circulated, and distributed. Either it contains an incorrect statement or it contains an omission because of which it has become misleading. Then all the persons who authorize the issue of prospectus, all of them will be punished under section 447. What is the punishment? Punishment is minimum 6 months, maximum 10 years imprisonment and fine. Imprisonment and fine. How much fine? Maximum 3 times the amount of the fraud. Okay, now listen, there is also an exemption. That is, these persons who authorized the issue of prospectus, I will not punish these persons in 2 cases. Number one, if they are able to prove that, okay, there was an omission, but that omission was immaterial. Yes, there was a concealment of facts, but that concealment of facts was immaterial. There was an omission, but that omission was immaterial. Or if that person is able to prove that he had a reasonable ground to believe, and he did believe till the time of issue of prospectus, he had a reasonable ground to believe, and he did believe what? He believed that the statement was true. See, listen, I told you initially itself, section 34 applies only if there is mens rea. That is, purposely I put a wrong statement. But if I'm able to prove that I genuinely believed the statement was true, I did not know the statement is wrong, I genuinely believed the statement was true, I did not purposely put the wrong statement. According to me, that statement was true only. I did not know this is a wrong statement. If I'm able to prove that, then there is no mens rea. In that case, I will not be punished under section 34. Now, section 34, criminal liability, precondition is that there must be mens rea. Criminal Procedure Code under Criminal Procedure Code 1973 will apply. We will treat as if company has done an offense against the entire state. Here, the prospectus has been ICD. Prospectus has been issued, circulated, distributed. Either it contains an incorrect statement or it contains an omission because of which the prospectus has become misleading. In that case, all the persons who authorize the issue of prospectus, I will punish them all under section 447. Under section 447, I will punish them with imprisonment minimum 6 months, maximum 10 years, and I will punish them with a fine which will be maximum 3 times the amount of fraud involved. But I will not punish them. If they they are able to prove that, okay, there was an omission, but the omission was immaterial. Or if they are able to prove that I did not know this is an incorrect statement. I had reasonable ground to believe, and I did believe till the time of issue of prospectus. I genuinely believed that the statement was true. I did not know that it is a wrong statement, which means there is no mens rea. So in that case, I will not punish those persons. Crystal clear with section 34, guys? Yes. Then coming to my next discussion is about section 35, which talks about civil liability. Now see, in criminal liability, what was the precondition? Here the precondition was mens rea. In civil liability, the precondition is that somebody should have suffered a loss. Because of the misstatement in the prospectus, some shareholder should have suffered a loss. That is a precondition. In civil liability, I will apply the code of civil procedure. I will apply the code of civil procedure, CCP we call it, the code of civil procedure year 1908. In criminal liability, we apply criminal procedure code 1973. Here we will apply the code of civil procedure 1908. And then over here, we will treat as if the company has done an offense against counterparty. That is, see, under criminal liability, we said that we will treat as if company has done offense against the entire state. But here we will treat as if the company has done offense only against one specific person. The company has done an offense only against a particular party who has suffered a loss. Company has done offense only against that party. Okay. Then under criminal liability, who and all was punished? Only persons who authorized the issue of prospectus, only they were punished. But under civil liability, guys, 5 people will be punished. Who are the 5 people? Number 1, directors. Number 2, all those persons who are actually not directors, but they are authorizing the company. Put my name also as director. They're actually not directors, but they're authorizing the company to put their name also as director. Then number 3, I will punish the promoters of the company. Number 4, I will punish all those persons who had authorized the issue of prospectus. I will punish them also. The same person was punished under criminal liability also. Okay. And number 5, I will also punish the experts. Now, these 5 people will be personally liable. Now, they will be personally liable to whom and for what amount? They will be personally liable to all those persons who relied on the prospectus. Relying on the prospectus, they subscribed to the shares of the company. They subscribed to the shares of the company, and then they realized that the prospectus is a misleading prospectus, and because of which they have suffered a loss. So for this loss, these 5 people will be personally liable. So these 5 people will be personally liable for the loss suffered by people who have relied upon this misleading prospectus. Relying upon the misleading prospectus, keyword, they have subscribed to the company's shares. You cannot write purchased the company's shares. Now listen to me. Subscribed to the company's shares means what? It means this person has directly purchased the shares from the company. He has directly subscribed the shares to the company and got the shares from the company. But if this person has bought the shares from the stock market from an existing shareholder, if he has purchased shares, then I will not apply civil liability. Are you understanding? Civil liability will come into the picture only if you subscribe to the shares. Subscribe to the shares means you should have directly purchased the shares from the company. If you're going to buy the shares from the stock market, that is, if you're going to buy the shares from existing shareholders, here I will not apply civil liability at all. Okay, so under civil liability, these 5 people will be personally liable for the loss suffered by a person who subscribed to the company's securities, relying upon the prospectus, and hence suffered a loss. Here, the key word, will you remember this, guys? Keyword, not purchased securities. Keyword, he subscribed to the securities. Still clear with this? Yes. Now listen, even over here, we will obviously have exemption, guys. Even in criminal liability, we had exemption. We had said that in criminal liability, these persons who authorized the issue of prospectus, they will not be punished, we said. Okay, we have said that they will not be punished. These persons will not be punished if they're able to prove omission was immaterial, or if they're able to prove that we had reasonable grounds to believe, and we did believe that the statement was true. So then we will not punish these persons under criminal liability, we had said. So even under civil liability, we will not punish them. Even under civil liability, we have some exemption. What is the exemption? Listen to the exemption one by one. The very first exemption. Listen to me. There was this person who had given his consent that he will be director of the company. He had given his consent. But before the company could issue the prospectus, he had withdrawn the consent, which means on the date of issue of prospectus, he is not the director of the company, guys. So if he is, so this first exemption is basically targeting only directors. So on the date of issue of prospectus, he had withdrawn his consent, which means on the date of issue of prospectus, he is actually not a director. So which means his name should not have been written in the prospectus as director, but his name is still written as director. But in reality, he's not a director. So don't punish him. So all those directors who had withdrawn their consent before the company could issue prospectus, we cannot punish them. Then, number 2, any person who is able to prove that the prospectus was issued without his knowledge. If I belong to any of these 5 categories, okay, but let us say I'm able to prove that I was busy vacationing in the US, I did not even know behind my back company issued prospectus. So the prospectus was issued without my knowledge, without my authority. As soon as I came to know about it, I gave a reasonable public notice, RPN. I gave a reasonable public notice saying prospectus is issued without my knowledge. So later, if there is any problem, don't come to me, don't hold me liable. So now if there is a misstatement, please don't hold me liable. Because the prospectus was issued without my knowledge, it was issued without my authority. I did not even know the prospectus was being issued. Later, when I came to know the prospectus was issued, I immediately gave a reasonable public notice saying that later, if there's any misstatement in the prospectus, don't hold me liable because this prospectus was issued without my consent. So now if you've identified a misstatement, don't hold me liable. And last situation, the last exception is applicable to the first 4. The first 4 are saying, listen, the misstatement is in the expert statement. So punish the expert. Why are you punishing us? If the misstatement is in the expert statement and if the other 4 are able to prove that they genuinely believed that this expert was a competent, we did not know there will be a misstatement in the expert statement also. We thought he's an expert. We thought he's competent. We trusted his expert statement. We did not know that there is a misstatement in his expert statement itself. So, if the misstatement is in the expert statement, the other 4 people can escape saying, punish the expert, don't punish us. So in these 3 cases, they can escape from civil liability. Number 1, the first point is targeting directors. So the director is able to prove that yes, I had given my consent to be director, but before the company could issue the prospectus, I had withdrawn my consent, which means on the date of issuing the prospectus, I was not a director. Number 2, if any of these 5 people are able to prove that the prospectus was issued without their knowledge, prospectus was issued without their consent, as soon as they came to know that the prospectus was issued, immediately they had given an RPN, reasonable public notice. Then, if the misstatement is in the expert statement, other 4 people can escape saying, we genuinely believe expert is competent. We did not know expert himself is not competent. So don't punish us. All right, guys. So in these 3 cases, we will not punish them. Civil liability will not apply in these 3 cases. And then talking about one last point, the whole burden of proof, the whole onus of proof is on whom? The full burden of proof, the onus of proof is on the allottee. Allottee means what? Allottee is this person who has subscribed to the company's shares. He only has to prove. What does he have to prove? First of all, he has to prove that there is a misstatement in the prospectus. Then he has to prove that this misstatement is a material misstatement. Then he has to prove that he has relied upon this misstatement. And finally, he has to prove that because of all this, he has suffered a loss. So the whole burden of proof, the whole onus of proof is on the allottee. He has to prove that there is a misstatement in the prospectus. This misstatement is material. He relied upon this misstatement and now see he has suffered a loss. This entire thing has to be proven by the allottee. Is still clear, guys? So this was my discussion regarding civil liability. So under misstatement in prospectus, we first of all learned what is misstatement. Misstatement means either I'm writing the wrong statement or I'm hiding important information, because of which my prospectus is becoming a misleading prospectus. Then we learned that if there is a misstatement in the prospectus, section 34 criminal liability will apply. Also section 35 civil liability will apply. Criminal liability will apply only if you purposely put the wrong statement. The criminal procedure code will apply. Mens rea is the precondition. We will treat as if company has done an offense against the entire state. Then what does section 34 say? Word to word, you should remember this. The prospectus has been ICD. ICD stands for what? ICD stands for prospectus has been issued, circulated and distributed. But it either contains an incorrect statement or it contains an omission, which means it is misleading. Now, all the persons who authorize the issue of prospectus, they will be punished under section 447. And under section 447, what is the punishment? They will be punished with imprisonment minimum 6 months and maximum 10 years. And they will also be punished with a fine, which is up to 3 times the amount of the fraud. And then we learned, however, we will not punish these persons if they are able to prove that there is omission, but omission is immaterial. Or if they are able to prove that they had reasonable grounds to believe, and they did believe till the time of issue of prospectus, they believed that the statement was true. Then finally, we learned about section 35, we learned about civil liability. Under civil liability, we said that here the precondition is that somebody should have suffered a loss because of the misstatement. Then we learned here Code of Civil Procedure 1908 will apply. We will treat as if company has done an offense only against a counterparty. Here we learned 5 people are going to be liable. Who are the 5 people? Directors. All those persons who authorize the company to put their name as director. Promoter, all the persons who authorize the issue of prospectus, and expert. These 5 people will be liable. Now, these 5 people will be personally liable. They'll be personally liable for what and to whom? They will be personally liable to all those persons who relied upon the company's prospectus, which is a misleading prospectus, and they subscribed, keyword subscribed. They subscribed, not purchased. They subscribed to the company securities directly from the company, not from the stock exchange, not through another shareholder and all. Directly from the company, they got the shares. And they suffered a loss. So for this loss, these 5 people will be personally liable, but they will not be held liable if directors are able to prove that before the date of issue of prospectus, they had withdrawn the consent, which means on the date of issue of prospectus, they are not directors. Or if they are able to prove that the prospectus was issued without their knowledge, without their consent, and later, as soon as they came to know about it, they had given RPN, they had given reasonable public notice. Or if they are able to prove that the prospectus, that the misstatement is in the expert statement, so punish the expert, don't punish us. And finally, we learned that the whole burden of proof is on the allottee. The allottee will have to prove that there was a misstatement, that misstatement was material, he relied upon the misstatement, and hence he has now suffered a loss. Is this crystal clear, guys? Yes, so this was our entire discussion relating to misstatement of prospectus. Yes, I hope this is thorough now. This is important, section 34 and section 35 relating to misstatement of prospectus. Okay, now coming to my next discussion, a nice big huge discussion relating to private placement. Let us have a discussion on this. This is going to be concept number 8. We are discussing about private placement. Now, relating to private placement, there are several rules and regulations. All those rules and regulations, all those conditions we're going to be seeing one by one now. See, first of all, what exactly is private placement? In private placement, the company is not making an offer to the general public. Here, the company is identifying a certain group of persons. Only to that selected group of people, the company is giving the offer. So here, the company is sending the offer. The company is offering shares not to the general public. The company is offering shares only to some selected group of persons. Now, how will the company offer shares? The company will have to send some document. That document is called as POCA. The document is called as private placement offer cum application. So in private placement, the company gives the offer not to the general public but to a selected group of people. And how does the company give them the offer? The company gives them the offer by sending them a document, a letter called private placement offer cum application. Okay, private placement offer cum application. Now only the selected group of people, only they can buy the company's shares, not anybody else. Okay, whenever the company is sending this POCA has to be sent by name, which means we cannot write hi. We have to write hi, the name of the person. You're understanding? For example, hi, Mr. John, or dear Mr. John, this offer is for you. This the POCA cannot have words like dear all or hi there. So you have to put the name of the person to whom are you making the offer. Now only that person can buy the shares. Nobody else can buy the shares. Okay, then the company has to keep a proper record. It has to keep a proper record of the list of the names to whom the company has sent POCA. Why should the company do this? Because from the date on which the company sends POCA, from that date, within 30 days, the company has to file that list with the ROC. So company has to keep a proper record that to whom has the company sent the POCA. Understanding, guys. So first point, the company has to offer shares. In Poca, the company is not offering shares to the entire public. The company is offering shares only to a selected group of people. And how does the company offer shares to them? Company offers shares to them by sending a document to them called private placement offer cum application. Then we learned that this private placement offer cum application will always be sent by name, which means it will be addressed to you by name. Your name will be written. Only the person whose name is written, only that person can buy the shares and not anybody else. Then we said company has to keep a complete record, a proper record of the names to whom the company has sent this offer. The reason being, from the date on which the company sends this offer letter, within 30 days, company has to file a copy of this list with the ROC. Okay. Then listen, there are several conditions that the company has to fulfill relating to private placement. If any of these conditions are violated, we will treat the private placement as if it is a public offer. And if we start treating it as public offer, all the SEBI rules and regulations will start applying. Okay. Now, what are these conditions? Listen to the first condition. At the maximum in a financial year, at the maximum, company can send this offer, company can send the POCA to maximum 50 people. But this is what the act says. But the rules say that we can send it to maximum 200 people. So out of these two numbers, which number will we apply? We will apply the 200 number, which is set by the rules. Because the act says 50 or such other number as may be prescribed, which means the act is saying I am submissive, I am subservient, I am weaker. If rules, if anywhere else, any other number is prescribed, you follow that other number. There is another number prescribed. The rules have prescribed 200. So this will be the final number. So the first point is that in a year, the company can give this offer to maximum 50 people as per the act. But the rules say 200. So out of these two numbers, 200 is what we will apply. But this, when you're counting 200 people, this 200 people will not include qualified institutional buyers. It will also not include employees. It will not include employees to whom I am giving ESOPs. It will not include employees. It will also not include qualified institutional buyers. Apart from these two, other persons to whom we have sent POCA should be less than or equal to 200. Okay. Then this limit is per security, which means equity shares I can send 200 POCA. Preference shares I can send another 200 POCA. Debentures I can send another 200 POCA. So per security, the limit is 200. But this limit itself is not applicable to non-banking finance company. This limit itself is not applicable to housing finance company, which means these two companies can send POCA to any number of people. Okay, this is a very, very important condition. In a year, per security, we can send POCA to maximum 50 people as per the act, 200 as per the rules per security. But that 200 number will not include qualified institutional buyers. It will also not include employees to whom I have given ESOPs. But this limit itself is not applicable to NBFC. It is also not applicable to housing finance company. Now, these people, these 200 people, if they want to accept the offer, they will send money to the company, right? They will send the share money to the company. That money they have to send through banking channels only. They cannot send this money through cash. Those 200 people, those that selected group of people, if they want to buy the company's shares, then they will send the money to the company for the shares. That money they have to send only through banking channels like check, demand draft and all, but they cannot send it by cash. Okay, then the company will maintain a proper record of the bank account details. Company will maintain a proper record of the bank account details from which the company has received all this money. Proper record of the bank account details has to be maintained by the company. All right. Now, listen, there's a very, very important point coming up. This entire share application money, this entire money which the company has received, the company will keep this entire money into a separate bank account, because two things are possible. What are the two things possible? Either the company may be able to allot shares, or the company may not be able to allot shares. If the company wants to allot the shares, the company should allot the shares within 60 days. We should see when did the company receive the money. From the date of receipt of money, within 60 days, it should allot the shares. Once the company allots the shares within 60 days, then within the next 15 days, the company should file return of allotment with the ROC. Once this is done, only then the company can start using the money. But in this 60 days period, if the company is unable to allot the shares, in that case, in the next 15 days, the company should refund the money. So whatever money the company has received, the company has to keep the entire money into a separate bank account. Okay, company has to also keep a proper record of the bank account details from which the company has received the money. Now, from the date of receiving the money, from that date, within 60 days, the company should actually allot the securities. If the company is unable to allot the securities within 60 days, then within the next 15 days, it should refund the money. If it doesn't refund the money within 15 days, then 12% per annum interest the company has to pay. But if the company is able to allot the shares within 60 days, then within the next 15 days itself, it has to file return of allotment with the ROC. And only then it can start using the money. But if it is unable to allot within 60 days, then within the next 15 days, it should refund the money. If it doesn't refund the money within the next 15 days, then we will ask the company to pay 12% per annum interest for the period of the delay. Then talking about the next point, this private placement, is it for the general public? No, it's only for the selected group of people. So therefore, company, please don't advertise. Please don't market it too much. See, I'm not telling the company keep it secret. I'm telling the company don't go around marketing about it, distributing about it, advertising about it. Don't do all that. Don't keep it secret. Don't keep it confidential, but also don't advertise and confuse the public, because anyways, this is not for the general public. Then this private placement should be for a minimum offer size. Minimum offer size of how much? Minimum offer size should be 20,000 rupees face value, not 20,000 shares. The minimum issue size should be 20,000 rupees face value. Minimum issue size should be 20,000 rupees face value. Is this crystal clear? Yes. Then if you want to make a private placement, the existing shareholders will have a problem. Why existing shareholders will have a problem? Because if I make a private placement, then in that case, more number of shareholders will enter the company. So existing shareholders, their control over the company will become lesser. There'll be dilution of control. So I need permission from them. How will I get permission from them? I have to get a special resolution passed. Now, how will I get a special resolution passed? I will call a meeting. How will I call a meeting? I will call a meeting by sending a notice to them. To this notice, I will attach one explanatory statement. In this explanatory statement, I will write all the details about the private placement. Like, for example, to whom am I making the private placement? How many shares am I offering? Why am I offering? At what price am I offering? When am I offering? All the details I have to put in the explanatory statement. Attach this explanatory statement to the notice and invite the shareholders come for the meeting. And in the meeting, I have to ask them to pass a special resolution. All right, guys. Then listen, this private placement offer come application, a copy of this also has to be filed with the ROC. And then talking about one last point, in private placement, there is no renunciation option. See, renunciation option is something which you have in rights issue. In rights issue, if I don't want to buy the rights shares, I can pass on the rights shares to somebody else. Here, private placement has gone by name. So Mr. John and only Mr. John can buy the company's shares. He cannot pass on the shares to any other person. He cannot renounce. Renounce means what? He cannot transfer the right to buy shares to any other person. If he wants, he can buy the shares and then sell. But he cannot pass on the right to buy shares to anybody else. Mr. John and only Mr. John can use this POCA and buy shares of the company. All right, there is no question of renunciation over here. So this was our entire discussion relating to private placement. Are we all crystal clear with this discussion also, guys? Yes, we've gone through each and every point under private placement. All right, so under private placement, we have learned that company, you're offering securities to a selected group of people. And how does a company offer securities to them? By sending them a document called private placement offer come application. By sending them a document called POCA. What does POCA stand for? Private placement offer come application. Okay, then after that we learned that here company has to maintain a proper record of the list of names to whom the company has sent the offer, because from the date of sending POCA, within 30 days company has to file a list with the ROC. Then we learned that there are several conditions. If any of these conditions are violated, I will start treating the private placement as if it is public offer. Once I start treating it as a public offer, all the SEBI rules and regulations will start applying. Then we learned that in a year company can make this offer maximum to how many people? Maximum to 50 people as per the act, and as per the rules 200. Now 50 or 200 we concluded out of these two numbers. I will choose 200. Then we learned that this 200 number will not include qualified institutional buyers. It will not include even employees to whom I have given ESOPs. Okay. Then we learned this limit itself will not apply to NBFCs and housing finance companies. Then we learned that whatever money we have received against these shares, we have to keep all this money into we have to get all this money only through banking channels and not through cash. And company has to make a proper record record of all the bank account details from which we have received this money. All this money we have to keep into a separate bank account. We have to see, are we able to allot the securities? Once we allot the securities within 60 days, then within the next 15 days, file the return of allotment, only then start using the money. But if we are unable to allot within 60 days, then we are supposed to refund the money within the next 15 days. If we don't refund within 15 days, then 12% per annum interest we have to pay. Then we learned company, this is not for the general public. Don't advertise, don't market about it and all. Minimum offer size, 20,000 rupees face value. Before you make private placement, call a separate meeting of the shareholders. Call a meeting by sending a notice to them. To the notice, attach explanatory statement. In that explanatory statement, write all the details about private placement. Call them for the meeting and ask them to pass a special resolution. Then we learned a copy of the POCA we also have to file with the ROC. And finally, we learned that we should not give any renunciation right to under private placement. Crystal clear with this entire discussion, guys? Yes, so this was our discussion regarding private placement. Please remember the section number of private placement. Private placement comes under section number 42. Private placement section 42. Okay, guys. Now listen, a connected concept, one small connected concept I want to discuss with you over here. If my company wants to issue convertible debentures, or if my company wants to issue convertible preference shares, convertible debentures or convertible preference shares, then don't you think even over here my shareholders will have a problem? Because not today, but in the future, once these debentures and preference shares are converted into equity shares, more number of equity shares we will have. So existing shareholders, their control over the company will become lesser. So that is why if we want to issue convertible debentures, if we want to issue convertible preference shares, even here we need prior special resolution of our shareholders. So we need special resolution not only when we do private placement, we also need special resolution when we issue convertible debentures and when we issue convertible preference shares. All right, guys. So this was our discussion regarding private placement. So we are done discussing with the 3 important questions from the prospectus chapter. Now, from the prospectus chapter, even though I have only these 3 important questions, if you look at the set B questions, I have one more, even in set B, I haven't put it, but there's actually one more thing I want to discuss with you about variation in the object. All right, listen to me, guys. These are the 8 concepts that we've discussed. Just one extra concept I want to discuss with you. See, let us say in the prospectus, it is written that the company can use the money for steel business. In the prospectus, it is written that the company wants to raise money because it wants to set up a new steel plant, let us say. Now, after raising the money, can the company say, no, not steel plant. I'm going to use this money for paper plant. This is what I'm talking about. I'm talking about changing the object for which the company has raised the money. Okay, changing the object for which the company has raised the money, or changing some terms of contract. Like, for example, let us say the company is raising money because a company, let us say Hyundai, is going to enter into a contract with Tata Motors. Together, both of them are going to set up a car manufacturing plant. All right. Now, because 2 well-known names, many of us subscribe to the company securities. After that, the company wants to change the contract. They're saying not Tata Motors, we are going to do it with Kia Motors instead. So either the company has raised the money, company has issued the prospectus. After issuing the prospectus, after raising the money, the company wants to change the object, or the company wants to change the terms of the contract. Are you understanding what situation I'm talking about over here? We are either changing the object or we are changing the terms of the contract. Now, if you want to do this, what is a process that you have to follow? See, generally you can't do this. If you do this, it is ultra vires the company. It is beyond the powers of the company. But if the company still wants to do this, the company has to follow 4 steps, 4 conditions it has to fulfill. It has to follow 4 steps. What are the 4 steps? First of all, we have to pass a special resolution. How will we pass a special resolution depends upon, are we changing the objects or are we changing the terms of the contract? If we are changing the object, okay, if we are changing the object, then we have to pass a special resolution through postal ballot. If we are changing the terms of contract, then we have to pass the special resolution at the general meeting. Second condition, we have to put the details about this change along with the justification. We have to publish this as an advertisement in 2 newspapers, one English newspaper, one vernacular newspaper, having wide circulation in the place where RO is situated. Number 3, details about this change we also have to publish into the website of the company. Lastly, whoever are the dissenting shareholders means shareholders who are not okay with this change, we have to give them an exit opportunity. Exit opportunity means if they want, they can sell away their shares. They can sell away their shares to the existing shareholders of the company. They can sell away their shares to the promoters of the company, and they can leave the company. So if the company has issued the prospectus, and after issuing the prospectus, it wants to change the purpose for which it wants to use the money, or if it wants to change the terms of contract, okay, in that the company cannot do this change because this change is ultra virus the company. But if the company still wants to do this change, then first pass special resolution. How will you pass the special resolution? If you want to change the object, you will pass the special resolution by postal ballot. If you want to change the terms of contract, you will pass the special resolution at the general meeting. Then publish the details about this change along with justification in one English newspaper, one vernacular newspaper, having wide circulation in the place where RO is situated. Then put the details about this change onto the website of the company also. And finally, if we have any dissenting shareholders, give them an exit opportunity, that is, other shareholders and promoters will buy away their shares. This exit opportunity, by the way, is also called as recall option. Okay, guys, this was just one extra concept I wanted to discuss with you. All right. So with this, we are done learning with the prospectus chapter, important concepts as well. Okay, now I am taking you to the share capital discussion. Under share capital, I'm going to be discussing with you about totally 4 concepts: alteration of share capital, reduction of share capital, buyback, and debentures. We'll take all the 4 of them one by one. First of all, I am starting the discussion regarding alteration of share capital. Alteration of share capital, here it will be nice if you can remember the section number 61. Okay, until now we have discussed about 8 concepts. In fact, not just 8 concepts. If you actually start counting, we have covered a lot more than 8, a lot more indirect concepts we have covered. We spoke about listed, unlisted companies, small companies, section 10A, alteration of MOA, alteration of AOA, rectification of company's name. Remember, along with this, we also spoke about cancelling the company's name. ROC is cancelling. Then doctrine of indoor management. We also spoke about doctrine of constructive notice. We also spoke about doctrine of ultra virus. Then we spoke about abridged prospectus, shelf prospectus, red herring prospectus, misstatement in prospectus, private placement, and we also spoke just now about variation in terms of contract. These 8 concepts, are you all thorough? Any question from here you will be able to handle? Yes, is it all set in your memory? Yes, guys. Now listen, same focus, same attention, keep it up even for the rest of the discussion. All right, listen, I'm discussing with you right now about alteration of share capital, first of all, which comes under section under section 61. Listen to me. If you want to alter share capital, it can be altered in totally 5 methods. In the first method, I am either increasing or I am decreasing the authorized share capital of the company. Now, what is the authorized share capital? Authorized share capital is nothing but the maximum amount of capital which the company can raise. It is also called the nominal capital. It is also called as registered capital. It's also called as a nominal capital, also called as a registered capital. So if I want to increase or if I want to decrease the authorized share capital, then it will come under alteration of share capital. See, remember we had discussed some time back alteration of MOA. Yes, and under alteration of MOA, I had told you that alteration of capital clause we will be discussing a little later in the share capital chapter. This is that alteration of capital clause. This alteration of capital clause only is covered under section 61. So through these 5 changes which I'm going to be discussing with you, we are going to end up altering the capital clause. So number 1, I'm increasing or I'm decreasing the authorized share capital. Number 2, the company is having fully paid shares. These fully paid shares are getting converted into stock, or this stock is getting reconverted into fully paid shares. Then number 3, company has shares which are not taken up by the public. shares which are not taken up by the public. For example, the company's issued share capital, let us say the company was willing to offer to the public 1 lakh shares of rupees 10 each. So these many shares the company was offering to the public, but not necessarily the public will take up all these shares. The subscribed share capital, that is the public took up only 95,000 shares of 10 rupees each. So balance 5,000 shares of 10 rupees each, they are those shares which are not taken up by the public. So if the company wants, the company can cancel these shares. This is called as diminution of share capital. Diminution of share capital is nothing but I am cancelling the shares which are not taken up by the public. We were willing to give to the public 1 lakh shares, but the public took up only 95,000 shares. So how many shares public did not take up? Public did not take up 5,000 shares. So that is nothing but the unsubscribed shares. The shares which are not subscribed by the public. Not taken up by the public means shares which are not subscribed by the public. Unsubscribed shares, 5,000 shares. So from the issued share capital, we can remove these 5,000 shares. We can cancel these 5,000 shares. So now issued share capital will also become 95,000 shares of 10 rupees each. So I am altering the issued share capital. From the issued share capital, I am subtracting the unsubscribed shares. I am subtracting the shares which the public refused to take up. This is called as diminution of shares. Okay. Then number 4, you have consolidation of shares. What is consolidation of shares, guys? You're grouping shares together. And number 5, you have subdivision of shares, where each share you are splitting into smaller shares. Subdivision of shares is also called as splitting of shares. It is also called as stock split. Okay. In consolidation of shares, let us say the company is saying 10 shares, I'm going to group them together into one single share. That is consolidation. In subdivision, ulta, company saying 1 share I'm going to split into 10 shares. That is subdivision of shares. So if the company wants to do any of these 5 things, it will come under alteration of share capital. Company can do this by passing one simple ordinary resolution. Once it is done, within 30 days, the company has to file with the ROC the altered copy of MOA. By altered copy of MOA, if the company does any of these 5 things, it will result in the alteration of capital clause. And where is a capital clause? The capital clause is in the MOA. So the MOA is getting altered. So altered copy of the MOA, we have to file with the ROC within 30 days once we finish this alteration. You got it, guys. So alteration of share capital, which section, guys? Section 61. I am doing any of these 5 things. Either I'm increasing or decreasing the authorized share capital, or I'm converting fully paid shares into stock, or reconverting stock into fully paid shares, or we are cancelling the shares which are not taken up by the public. That is, we are, let us say, cancelling the unsubscribed shares, which is also called as diminution of share capital. From the issued share capital, we are removing the shares which are not taken up by the public. Then we are also doing consolidation of shares or subdivision of shares. In consolidation of shares, we are grouping shares together. In subdivision of shares, we are splitting shares into smaller parts. These 5 things come under alteration of share capital, and if I want to do these 5 things, I have to pass an ordinary resolution. Once I pass this ordinary resolution, within 30 days, an altered copy of the MOA, we have to file with the ROC. Okay, guys, come on, one last time. Tell me what are the 5 things. Tell me without seeing. Number 1, I am increasing or I'm decreasing the authorized capital. Number 2, I'm converting fully paid shares into stock or vice versa. Number 3, we are cancelling shares which are not taken up by the public. That is, we are cancelling unsubscribed shares. We are cancelling unsubscribed shares, which is also called as diminution of share capital. Then number 4, consolidation of shares, and number 5, subdivision of shares. Okay, so this was our discussion regarding alteration of share capital. Now listen to my next discussion, guys. My next concept, we're going to be learning about reduction of share capital. Now, reduction of share capital, even over here, you should remember the section number, which is section 66. So section number 61 was Section 61 was alteration of share capital. Then section 66 we're going to be discussing now, which is going to be about reduction of share capital. Now, we are going to go through this in full detail point by point we're going to revise. Listen, first of all, what is the meaning of reduction of share capital? What is the meaning of reduction of share capital? What are the various methods in which the reduction of share capital can happen? See, the reduction of share capital can happen in totally three methods. In the first method, we are reducing the liability of the shareholders. We are reducing the liability of the shareholders. Like, for example, let us say we have shares of face value rupees 10. Okay, and out of it, let us say the called up value is rupees 7. Okay, and the paid up value is also rupees 7. So which means, what is the liability of the shareholders, guys? How much money they have to bring in more? They have to bring in 3 rupees more. But I'm telling the shareholders, no need to bring in 3 rupees more. Bring in just 1 rupee, that will be enough. That is, I am reducing the liability of the shareholders. I am telling them they don't have to bring in 3 rupees. Bring in 1 rupee, that itself will be enough. You bring in 1 rupee. Once you bring in 1 rupee, paid up value will become 8 rupees. Called up value will become 8 rupees. This face value we will reduce to 8 rupees. So it will be as if 8 rupees shares, 8 rupees fully paid up. Balance 2 rupees you don't have to pay. I am reducing the face value per share. You don't have to pay me the balance 2 rupees. I am reducing your liability itself. First method. In the second method, we are returning, the company is paying off excess paid up share capital. The company is paying off the excess paid up share capital, which is more than the needs of the company. For example, let us say the face value per share is rupees 10 and it is called up also rupees 10 and the paid up value is also rupees 10. Okay, but company is thinking, what do I do with so much money? So company is telling the shareholders, I don't need so much money. I will return 2 rupees back to you, which means paid up value will become 8, called up value will become 8. It depends on the company. If it wants, it can keep face value as 10 itself, which means it will become face value 10 rupees, 8 rupees paid up. So balance 2 rupees for now we are paying off. But later, if the company needs the money, company can ask the money again. Or if the company wants, even face value it can reduce to 8, which means it will become 8 rupees share, 8 rupees fully paid up. You're understanding? So what are the methods? What are the 3 methods in which you can reduce share capital? In the first method, I am reducing the liability of the shareholders. Shareholders are supposed to pay 3 rupees per share. I am telling them no need to pay 3 rupees per share. Pay me 1 rupee, that will be enough. If you pay me 1 rupee, paid up value will become 8 rupees. Called up value will become 8 rupees. Face value is 10. I will reduce 10 also to 8. So it will be as if 8 rupees share, 8 rupees fully paid up. You don't have to pay me the balance 2 rupees. I'm reducing your liability. In the second method, we are paying off the excess paid up share capital, which is more than the needs of the company. We are returning the excess paid up share capital, which is more than the needs of the company. Which means, let us say, that the shareholders have, paid 8 rupees, full 10 rupees they have paid. But the company is thinking this is too much money. The company doesn't need so much money. So what the company is doing is, out of this 10 rupees, it is returning 2 rupees back to the shareholders. It is telling the shareholders, I do not need this 2 rupees. So paid up value was earlier 10. They are returning 2 rupees back to the shareholders. So what's the paid up value now? The paid up value is now 8. Now, if the company keeps face value as 10 itself, then the company is playing safe. In that case, face value 10 rupees, paid up value 8 rupees. So later, whenever the company, needs money, company can ask shareholders to again give 2 rupees. For now, we are returning 2 rupees. Later, if we need money, we'll get 2 rupees again from them. Or if the company wants, company can reduce the face value to 8. If it reduces face value to 8, then it will be 8 rupees share, 8 rupees fully paid up. Did you understand both these methods? Everybody, guys, are you all crystal clear with both of these methods? In the first method, we are reducing the liability. In the second method, we are returning the excess capital. Depends upon the company. It may reduce the face value. It may not reduce the face value. Okay. Then talking about the third method. In the third method, what is the company doing? This is the most important method. Here, the company is writing off the lost paid up share capital. What do you mean by lost paid up share capital? It is that paid up share capital which is not represented by assets of the company. It is not represented by assets. See, guys, in my balance sheet, if I have capital 100, I should have assets also 100, guys. But let us say I have capital 100, but I have assets only 90. What happened to the balance 10? The balance 10 is P&L, debit balance, which means the balance 10 loss. Balance 10, we don't have assets. Out of this 100, we have assets only for 90. To the extent of balance 10, we don't have assets. So balance 10 is lost capital. The balance 10 is lost paid up share capital. To the extent of this 10 rupees, we don't have assets left in the company. We have lost that much money. So what the company can do is the company can pass the entry capital account debit to P&L account. By doing this P&L will be removed from the balance sheet and this capital will become 90. Reduction of capital from 100 to 90. This is called writing off the loss paid up share capital. That is writing off the paid up share capital which is not represented by assets of the company. Here, I am just writing off the P&L debit balance against the capital of the company. I am writing off the loss paid up share capital of the company. Understanding. So, reduction of share capital can happen in any of these three methods. You understood the third method also? Yes, I have capital 100, but I have assets only worth 90. So to the extent of the balance 10 rupees, I don't have assets anymore. So that balance 10 rupees assets, to that extent, I will write off the capital because to that extent, my capital is lost. To that extent, I don't have capital. So that is why to that extent, I will write off the capital. I will reduce the capital. So out of 100, I will keep only 90. I'll keep only to the extent to which it is represented by assets, the balance I am writing off. So these are the three methods in which you can reduce capital. Now, what is the process that you have to follow if you want to reduce capital? The process for reduction of capital, listen to me carefully. Step number 1, you have to check that the articles of association should authorize, which means in the AOA, it should be written that if this company wants to reduce share capital, it can reduce share capital. AOA should authorize the reduction of share capital. Then second step, we have to pass a special resolution. We have to call a shareholders meeting and we have to ask them to pass a special resolution. Then number 3, there should not be any subsisting default relating to deposits. If there is any subsisting default relating to deposits, company, please rectify the default first. Once you rectify the default, only then we will let you reduce the capital. First 3 steps, did you understand, guys? What are we learning? We're learning the process. In the process, the first step was AOA should authorize. Second step, special resolution I require. Third step, there should not be any subsisting default relating to deposits. Now listen to the rest of the process. The rest of the process I will simplify for you by giving you one single diagram. Listen to the next set of steps. The company has to make an application to NCLT. We need NCLT's permission. So company has to make an application to NCLT requesting the NCLT, please let me reduce the share capital. As soon as NCLT gets this application, NCLT will behave like one typical gossip aunt. What do the aunts in our families do? As soon as they get some information, immediately they spread the information to 5 different people. That's what even NCLT will do. As soon as NCLT comes to know that company wants to do reduction of capital, it will immediately it will give a notice of this application to 4 different people. Who are these 4 different people? Number 1, central government. Number 2, ROC. Number 3, SEBI. SEBI obviously only if the company is a listed company. And number 4, it will also inform the creditors. Now, if any of them have any representation, if any of them have any objection, but we will not use the word objection, we will use a legal word or a formal word, representation. If any of them have any representation, they have to send the representation to NCLT within 3 months. See, if others are sending an objection, still understandable. But if the creditors are sending an objection, then it is a serious matter. If the creditors are objecting, we either have to discharge the creditors, which means repay them, or we have to somehow get their consent, or we have to give them some security. Okay, then after all this, once all this is done, now and the NCLT will still not give permission, because now the next worry for the NCLT will be accounting. This reduction of share capital is pretty complicated for accounting process. So NCLT will be worried whether accounting will happen properly or not. So for that, the auditor will give a certificate to the company saying that don't worry, that the accounting will be exactly as per the applicable accounting standards, and company will file a copy of the certificate with the NCLT, that auditor certificate we will file with the NCLT. Now NCLT is convinced, NCLT will pass an order allowing the company that yes, you can go ahead with a reduction, but still company cannot do reduction. Now what is pending? Company has to go to the ROC. Company has to give to the ROC totally two things. Number one, company has to give to the ROC a copy of the NCLT order, and number two, company has to give to the ROC minutes which are approved by NCLT. Minutes will be nothing but a summary of this entire process, which is even approved by the NCLT. These two things the company will give to the ROC. Okay. Now, what will the ROC do? The ROC will make a note of this. The ROC will register the reduction. We will see when did the ROC register the reduction. On this date only, this reduction is going to be effective. And lastly, the company has to publish, number one, the fact that it has done reduction of capital, and number two, the reason that why did it do this reduction of share capital. Got it, guys? So this was our entire process relating to reduction of share capital. So first of all, the articles of association should authorize. After that, we have to pass a special resolution to get shareholders' permission. Number three, there should not be any subsisting default relating to deposits. Then after that, the company has to file an application with NCLT. NCLT will immediately give a notice of the application to these four people. These four people, if they have any representation, they will send the representation to NCLT within 3 months. Then if the creditors are objecting, we either have to discharge the creditors or somehow get their consent, or we have to give them some security. Okay. Then the auditor will give a certificate to the company saying that the accounting will be as per the accounting standards. Company has to file that auditor certificate with the NCLT. NCLT will then pass an order allowing the company, yes, you can go ahead with a reduction. Then company will file a copy of NCLT order along with minutes approved by NCLT with the ROC. Okay. Then what will the ROC do? Then, just a moment, guys. Then the ROC will register the reduction of share capital. All right. Once the ROC registers the reduction of share capital, that is when the reduction will be effective. And finally, we will publish this entire fact of reduction along with reasons for the reduction. We will publish it where in 2 newspapers, in one English newspaper, one vernacular newspaper, having wide circulation in the place where RO is situated. So this is the entire process of reduction of share capital. One last time, AOA should authorize, special resolution has to be passed. There should not be any subsisting default relating to deposits. Then we have to file an application with NCLT. NCLT will give a copy of the notice to 4 people. If they have any representation, they will send representation within 3 months. If creditors are objecting, we have to either discharge the creditors or get their consent or give them some security. Then after that, the auditor has to give a certificate to the company saying that the reduction of capital, saying that the accounting will be as per the accounting standards. Copy of that auditor certificate we will file with the NCLT. Then NCLT will pass an order allowing the company, you can go ahead with the reduction. Then company will file a copy of NCLT order with the ROC along with minutes approved by NCLT. Then ROC will register the reduction. That day only the reduction will be effective. And finally, we have to publish the fact that we did the reduction along with the reason for the reduction we have to publish. Got it, guys. One last point under reduction of share capital. I'm going to be telling you about 6 situations. In all these 6 situations, if you see, in some way or the other, the capital is becoming lesser, but still Section 66 will not apply. In these 6 situations, the capital of the company is becoming lesser, but still Section 66 will not apply. What are these 6 cases? Number 1, if any shareholder surrenders shares. Number 2, if the company forfeits shares. Number 3, if there is diminution of share capital, diminution of share capital, what do we do over here? We cancel the unsubscribed shares. We cancel the shares which the public is not taking up. Then when we redeem preference shares, redemption of preference shares, even over here the total share capital of the company is becoming lesser, but I don't apply Section 66. Then when we buy back the shares, and finally when the company purchases shares because of a court order. So in these 6 cases, guys, section 66 will be not applicable. In these 6 cases, section 66 is not applicable. In all these 6 cases, if you see, in some form or the other, there is a reduction of share capital. In some form or the other, the capital of the company is becoming lesser, but I cannot apply section 66. What are the 6 cases? Number 1, surrender of shares. Number 2, forfeiture of shares. Number 3, diminution of shares. That is, I'm cancelling unsubscribed shares. Number 4, redemption of preference shares. Number 5, buyback of shares. And number 6, purchase of shares under a court order. All right, guys. So this was my entire discussion with you regarding section 66, which is one of the biggest sections of this chapter. Are you confident with section 66 also? Yes, I'm sure the entire process, at least, you're pretty thorough. Yes, so with this, we come to an end to one more discussion regarding reduction of share capital. So let's go forward, guys. Let's go to the next set of discussions. So we just spoke about section 66, which was about reduction of share capital. Now, the next discussion we're going to be revising about buyback of securities. Now, even under buyback, you should be remembering the section number, which is section 68. Okay, now let me discuss with you all the points relating to buyback one by one. Now, first of all, from whom is a company going to buy back? The company has 3 options. Either the company can buy back the shares from the existing shareholders. The company can buy back shares from the existing shareholders on a proportionate basis. That is, company can have a ratio. Like, company can come up with a ratio 1:5, which means if you're having 5 shares, company is going to buy back 1 share. Or the company can buy back shares from the existing shareholders in the open market. In the open market, company will not have any ratio. Whoever is willing to give how many ever shares, company will buy the shares from them. Or the company can buy the shares from the employees. And how did the employees get the shares? Either through either through ESOPs or through sweat equity shares, the employees have the shares. So the very first point, from whom is the company going to buy back the shares? Either the company can buy back the shares from the existing shareholders who already had the shares of the company on a proportionate basis, or the company can buy back shares from the existing shareholders in the open market, or the company can buy back shares from the employees who are already having shares of the company either through ESOPs or through sweat equity shares. Now, obviously, these people will not give their shares to the company for free. They will obviously charge the company for giving these for giving these shares. So the company has to pay money for buyback. So from where is the company going to get the money for buyback? Company has totally 3 options. Option number 1, the company can take the money from its free reserves. Option number 2, company can take money out of securities premium money, or the company can make a fresh issue of securities, and whatever the proceeds of these fresh issue of securities, from here the company can take the money and the company can buy back securities. But if the company is taking money out of free reserves or out of securities premium, I will see how much money did the company take from here, and using this much money, how many shares did the company buy back? That many shares face value we have to transfer into CRR, and CRR we will not use for any other purpose except for one purpose, which is to issue fully paid bonus shares. So my first point was about from whom is the company going to buy back shares. My second point is what are the sources of the resources? From where can the company take the money? What are the sources of funds? From where can the company take the money for the buyback? Because obviously the shareholders will expect some money, only then they will give their shares to the company. So the company can take money either out of free reserves, or the company can take money out of securities premium money, or the company can make a fresh issue of securities and use the proceeds of the fresh issue of securities. But if the company takes money out of free reserves or out of securities premium account, we will see using this much money, how many shares did the company buy back? That many shares face value we have to transfer into CRR. Then, if we want to do buyback, then we need a board resolution. But sometimes we also need a special resolution. It all depends upon how much money are we spending on buyback. If we are going to spend up to 10% of paid up share capital plus free reserves plus securities premium, in that case, we need just a board resolution. But we will also need a special resolution if we are spending more than 10% of paid up share capital plus free reserves plus securities premium. More than 10%, but maximum how much can we spend? Maximum we can spend only 25% of paid up share capital plus free reserves plus securities premium. Now answer my next point. Can the company buy back all the 100% of the shares? No, the company can buy back maximum only 25% of the outstanding shares. It cannot buy back all the shares. Maximum it can buy back only 25% of the outstanding shares. My fourth point. Then listen to my next point. After buyback, if you see the debt equity ratio after buyback, debt equity ratio means what? The total debt divided by equity. If you do this calculation, where equity is nothing but paid up share capital plus free reserves plus securities premium. If you do this calculation after buyback, it should be less than or equal to 2. Debt by equity should be less than or equal to 2. Okay, then listen to my next point. If you want to buy back shares, the precondition is that the shares have to be fully paid up. Only fully paid up shares you can buy back. And then obviously, if the company is a listed company, then you also have to follow all the SEBI rules and regulations. Also, you have to follow if you want to buy back shares of a listed company. Then listen, in case you need a special resolution, how will you pass this special resolution? You will pass the special resolution at the general meeting, guys. Now, to pass the special resolution, you have to call a meeting of the shareholders. To call the general meeting of the shareholders, you will have to send them a notice. To this notice, you will have to attach an explanatory statement. Now, in this explanatory statement, you will have to write 5 things, and the hint to remember the 5 things is stand. You have to write 5 things in the explanatory statement. S stands for shares or securities. Basically, which shares, which securities are you buying back? Then T stands for time limit. What is the time limit within which you're going to complete the buyback? A stands for the amount. How much amount are you going to spend for the buyback? N stands for necessity. What's the necessity? Why are you doing the buyback? And D stands for disclosure of all other material information. So if you have to pass a special resolution, to pass a special resolution, you have to call a meeting of the shareholders. To call the meeting, you have to send the notice. To that notice, you have to attach an explanatory statement where you will write about 5 things. Number 1, which shares or securities are you buying back? Then number 2, the time limit within which you're going to complete the buyback. Then A, how much amount are you going to spend on the buyback? And necessity for the buyback, that why are you doing the buyback? And the disclosure of any other material fact relating to buyback. Then listen, there are some time limits which you have to remember relating to buyback. All the time limits I'll put over here in the form of one single diagram. Listen, we are passing a resolution, either board resolution or a special resolution, as the case may be. Whichever resolution we are passing, that resolution will have a validity period of 12 months, which means within 12 months, we are supposed to complete the buyback. Okay, once we complete the buyback, within the next 7 days, we are supposed to extinguish the shares. Extinguish the shares means we're supposed to destroy the shares within 7 days. Once you complete the buyback, within the next 30 days, you are supposed to file buyback return with the ROC. Once you complete the buyback, you are supposed to wait for 1 year. Only after 1 year, you can do another buyback. So time gap between 2 buybacks should be minimum 1 year. And lastly, once you complete buyback, you have to wait for 6 months. Only then you can issue more securities to raise more funds. If you want to raise funds by issuing securities, you have to wait for 6 months, which is also called as cooling period. So you have to wait for the 6 months cooling period. Only after that, you can issue more securities and you can raise funds. Now listen very carefully. If you want to make a bonus issue in the 6 months period, can you make a bonus issue? Yes, you can. Why? Because in bonus issue, funds are not getting raised. Also, in the 6 months, you can issue ESOPs, because in ESOPs, money is not coming in immediately. Money will come only after the vesting period. In these 6 months, also, can I convert my existing convertible debentures, my existing convertible preference shares, can I convert them into equity shares? Yes, I can do all the 3, because in all the 3, if you see right now, money is not flowing into the company. Okay, but in these 6 months, can I issue rights shares? No, rights shares I cannot issue, because when I issue rights shares, what happens? When I issue rights shares, money is flowing into the company. Okay, something lesser, but some money is flowing into the company. So we cannot issue securities to raise funds in these 6 months. All right, so there are totally 5 time limits which you should remember, guys. Number 1, the resolution will have a lifetime of 12 months. It will have validity of 12 months. Within 12 months, we should complete buyback. Once we complete buyback, within 7 days, we should extinguish the shares. Once we complete buyback, within 30 days, we should file the buyback return. Once we complete buyback, within 1 year, you cannot buy back again. And once you complete buyback, within 6 months, you cannot raise more money. So there's a cooling period of 6 months. Why do you have the cooling period of 6 months? Because see, when you're doing the buyback, you are returning the money to the shareholders, which means you're telling shareholders, I have surplus money. The next day itself, you cannot say, no, I need more money. Now you have to wait for 6 months. Only after 6 months, you can raise more money. But in the 6 months, you can do everything else through which money is not coming in. Like bonus issue, money is not coming in. You're issuing ESOPs. Today, money is not coming in. You already issued debentures, preference shares. You're converting into equity shares. In all the three, money is not coming in. So these three you can do even within these 6 months period. Are you crystal clear with this discussion of time limits, guys? Yes, all the time limits I put in one single diagram. It will help you recall later. Okay. Now listen to my next concept. The company has to maintain a separate register of buyback. In this register, it will put all the details about the buyback. Then the company also has to file a declaration of solvency. This is the most important point in the entire buyback declaration, in the entire buyback discussion. The company has to file a declaration of solvency in form number SH9. Through this form number SH9 has to be filed with whom? It has to be filed with both ROC and SEBI. Now, this form is going to be signed by any two directors. It has to be signed by at least two directors, and out of these two directors, one of whom will be the managing director. Now, this declaration of solvency has to be filed when it has to be filed before making the buyback. Now, what will you write in this declaration? You will write two things in the declaration. Number one, the board has made a full inquiry into the affairs of the company. And number two, on the basis of this inquiry, the board has formed an opinion. What opinion have they formed? They have formed an opinion that the company is capable of meeting its liabilities, and for the next 1 year at least, the company will not go insolvent. See, understand the logic behind declaration of solvency. See, don't you think the creditors will have a problem if the company is buying back securities? Because through buyback, what is the company indirectly saying? When I have surplus money, I want to return the money to the shareholders. That is why company is buying the shares from the shareholders and returning money to them. Don't you think creditors will say, oh company, if you have so much extra money, why don't you repay us? So that is why we want to tell the creditors that don't worry, creditors, we have enough money for you also. We are capable of meeting your liabilities also. We will not go insolvent. We have enough money for you also. That's a logic behind declaration of solvency. So declaration of solvency in form number SH9 has to be filed with both. It has to be filed with ROC and SEBI. Through this declaration of solvency, we are telling the creditors that we have made a full inquiry into the affairs of the company, and on the basis of the inquiry, we have formed an opinion that we are capable of meeting our liabilities. For the next 1 year at least, we are not going to be insolvent. We have enough money for you also. Don't worry, creditors. Understood this entire thing, guys? Then coming to one last point under buyback. If the company has made any default relating to deposits, if the company has made any default relating to redemption of preference shares or any default relating to redemption of debentures, or if the company has made any default relating to dividends, or if the company has made any default relating to bank loans, okay, then company first rectify the default. After rectifying the default, wait for 3 years. Only after 3 years you can buy back securities. Also, if the company is buying back securities, there should not be any default relating to annual return. There should not be any default relating to financial statements. Okay, so this is my entire discussion with you relating to buyback. Can we do one quick revision, one last revision of buyback, and then we'll close buyback at section 68. So first of all, from whom can the company buy back securities? The company can buy back securities only from the existing shareholders on a proportional basis, or company can buy back securities from the existing shareholders from the open market, or company can buy back securities from the employees to whom the company has given securities through ESOPs or sweat equity shares. To buy back securities, company needs money. From where will the company get money? Either the company can get the money out of free reserves or out of securities premium money, or the company can make a fresh issue of securities. Now, if the company is taking money out of free reserves or out of securities premium money, then we will see using this much money, how many shares did the company buy back? That many shares face value we will transfer into CRR, which we will not use for any other purpose except for buyback of except for issue of bonus shares. Then we learned we just need a board resolution if we are going to spend within 10% of paid up share capital free reserve securities premium. But if we are spending more than 10% but up to 25%, then board resolution plus special resolution is required. To pass special resolution, I have to call meeting of the shareholders. To call a meeting, I have to send a notice. To that notice, I have to attach an explanatory statement in which I will write 5 things. The hint to remember the 5 things is stand. S, which shares or securities am I buying back? T, time limit within which I will complete buyback. A, what is the amount which I'm going to spend on the buyback? N, what's the necessity for the buyback? And D, disclosure of all other material facts. Okay, then after that, we discussed that at the maximum, we can buy back only 25% of the outstanding shares and not more than that. Then we learned after buyback, debt by equity should be less than or equal to 2. Then we said we can buy back only fully paid shares. All right. And then we learned that if I'm a listed company, then I have to make sure I have to follow all the SEBI rules and regulations also. Then listen, after that, time limit. We learned about 5 time limits. Number one, if I want to, once I pass the resolution, within 12 months, I have to complete the buyback. Once I complete the buyback, within 7 days, I must extinguish the shares. Within 30 days, I must file the buyback return. For next 1 year, I cannot buy back again. And I have to wait for 6 months. Only then I can issue more securities and raise more funds. Then we learned within these 6 months period, I can make a bonus issue. I can issue ESOPs. I can convert my existing debentures or preference shares into equity shares. Then we learned company has to maintain a separate register on buyback. We spoke about declaration of solvency. Please remember the form number SH9. Form number SH9, declaration of solvency. Now this declaration of solvency has to be filed with ROC and SEBI. This has to be signed by at least 2 directors, one of whom shall be the managing director of the company. This declaration has to be filed before buyback. Okay. In this declaration, what will we write? We will write that the board of directors has made a full inquiry into the affairs of the company, and on the basis of the inquiry, the board has formed an opinion that the company is capable of meeting liabilities, and for the next 1 year for the next 1 year at least, the company is not going to be insolvent. All right, the board has made a full inquiry into the affairs of the company. On that basis, the board has formed an opinion that the company is capable of meeting liabilities. For the next 1 year at least, the company will not be insolvent. Then we learned if there's any default relating to deposits, redemption of preference shares or debentures, dividend, or repayment of bank loan and all, then company first rectify the default, then wait for 3 years, only then you can buy back securities. And finally, we learned if there's any default relating to annual return or financial statements, then I will not let the company buy back securities. First, you rectify the default, only then you can buy back securities. Are you thorough with section 68, guys? Yes, did everybody understand section 68? Yes, a good revision has happened. Yes, now see, listen, another passing reference, okay? I'm talking about fully paid up shares. In the share capital chapter, where else do I require fully paid up shares? If I want to make a bonus issue, even there the shares have to be fully paid up. Only then I can make a bonus issue. Then, if I want to redeem preference shares, I can redeem preference shares only if they are fully paid up. If they're not fully paid up, I have to make them fully paid up first, only then I can redeem preference shares. Also, when I want to convert shares into stock, which shares can I convert into stock? Only fully paid shares I can convert into stock. So in these 3 places, you talk about fully paid shares, bonus issue, redeeming preference shares, and converting shares into stock. In all these 3 places, you talk about fully paid shares. Okay, guys. So this was our entire discussion regarding a buyback. Okay, now I'm taking you to the next discussion, which is going to be about debentures. Our next concept, our next discussion, which is going to be about debentures. Now, relating to debentures, there are some important concepts which you should be knowing. I am discussing those important concepts with you. Listen to me one by one. What are the things that you should mandatorily know? First of all, once the company has allotted the debentures, from the date of allotment of debentures, within 6 months, the company has to send a debenture certificate to the debenture holders. So debenture certificate time limit is 6 months. Okay. Then listen to the next point, my next point of discussion. If the company wants to issue secured debentures, yes, the company can issue secured debentures. Now, relating to secured debentures, listen to 2 to 3 important points. The asset which we are giving as security, that asset should be sufficient not only to meet the debentures amount, but it should also be sufficient to meet the interest amount. Okay. Now, I can give asset of which company as security? I can give the asset of the company. I can give the asset of the associate company. I can give the asset of the subsidiary company, or I can give the asset of the holding company. Your hint is cash. I can give the asset of any of these 4 companies as security. I can give the asset of a company, associate company, subsidiary company, or holding company as security. But the asset should be sufficient not only to meet the debenture amount, but also to meet the interest which is due on the debentures. All right, guys. Then listen to my next point relating to debentures, my third point. The third point relating to debentures is that debenture redemption reserve. every year we have to see how much debentures are outstanding. Whatever are the outstanding debentures, that into 10%, this much money the company has to take out of its profits and transfer into debenture redemption reserve. So the company will create a separate reserve called debenture redemption reserve. The company will take 10% of the outstanding debentures out of the profits, and this much money company will transfer into DRR, and DRR I will not use for any other purpose except to redeem debentures. In other words, we are setting aside profits to redeem debentures. Okay. So 10% of the outstanding debentures we will transfer into debenture redemption reserve. Now listen to me carefully. This debenture redemption concept is not applicable to some companies. It is not applicable to all India financial institutions. It is not applicable to banks. It is not applicable to non-banking finance companies. It is not applicable to housing finance companies. It is not applicable to financial institutions, and it is also not applicable to listed companies. It is only applicable to other unlisted companies. Okay, so debenture redemption reserve, the company will see how much debentures are outstanding. 10% of the outstanding debentures, the company will take out of profits and transfer into a separate reserve called debenture redemption reserve. This debenture redemption reserve we will not use for any other purpose. We will use it only for one purpose, and that is to redeem debentures. Now, in this debenture redemption reserve, this concept itself is not applicable to all India financial institutions, banks, NBFCs, housing finance companies, financial institutions, and listed companies. Then, in addition to this, we have one more concept called debenture redemption investment. In debenture redemption investment, what happens is we will see how much debentures are maturing in the current year. What is the amount of debentures which are maturing in the current year? This much debentures which are maturing in the current year, I will calculate 15% of these debentures. 15% of these debentures. This 15% we will have to invest into prescribed investments or prescribed deposits. We have to put this much money into prescribed investments and prescribed deposits. This concept is independent of debenture redemption reserve. Debenture redemption reserve, the number is 10%. Debenture redemption investment, the number is 15%. We will see current year how much debentures are maturing. 15% of the debentures, we will take this much money and we will put this much money into prescribed investments or prescribed deposits on or before 30th of April of the current year. On or before 30th of April of the current year. But again, this concept of debenture redemption investment is also not applicable to all India financial institutions. It is not applicable to banks. Now, if it is NBFC or if it is a housing finance company, in these two companies, it is applicable to listed companies, but it is not applicable to unlisted NBFC, unlisted housing finance company. It is not applicable. It is also not applicable to financial institutions. To all other listed, unlisted companies, it is applicable. It is not, it is different from DRR. DRR is not applicable to all India financial institutions, banks. These two are common. Even financial institution is common. And DRR is not applicable to all NBFCs and HFCs, but DRI is not applicable only to unlisted NBFC and HFC. DRR is not applicable to all listed companies. DRI is applicable to other listed companies and unlisted companies. So there is a difference. Both are not applicable to all India financial institutions, bank and financial institutions. DRR is not applicable to all NBFC, HFC. DRI is not applicable to only unlisted NBFC, HFC. Other listed, unlisted companies, DRI is applicable. Will you remember the percentages, guys? What are the percentages? In DRR, 10%, DRI 15%. Okay. In DRR, we will see how much debentures are outstanding. 10% of the outstanding debentures we will take from our profits and we will put into DRR. In DRI, we will see how much debentures are maturing in the current year. That much debentures, 15%, we will take that much money and we will put that much money into investments and deposits on or before 30th April of the current year. Okay, guys. So this was our discussion regarding DRI, debenture redemption investment. Now listen to the next important point. At the maximum, how much debentures can the company issue? At the maximum, how much debentures can the company issue? Listen to me very carefully. We will see what are the existing loans in the company. The existing loans plus existing debentures in the company, plus what are the debentures which the company wants to issue right now. Basically, all the loans put together. there is a limit. The limit is it should be within paid up share capital plus free reserves plus securities premium. But if the company wants to exceed this limit, if it wants to go more than this limit, it is possible. It simply has to pass a special resolution. And also remember, when you talk about existing loans over here, you will not bother about short-term loans. You will not bother about temporary loans. You will look at only the long-term loans. The long-term loans plus debentures which the company now wants to issue, everything put together should be within paid up share capital plus free reserves plus securities premium. But if the company wants to issue more than this much limit, it is possible. In that case, just remember that we just need a special resolution. If you want to exceed this limit, we just need a special resolution. Okay. Then listen to my last point under debentures. We also have to understand about a debenture trustee. We also should know about some points relating to debenture trustees. See, listen, what do these debenture trustees do? They do totally three things. What is their role? First of all, they have totally three roles to play. Number one, they protect the interest of the debenture holders. Number two, they redress their grievances. Redress their grievances means if the debenture holders have any complaint, they will go and complain to the debenture trustee. Number three, they call a meeting of debenture holders. Now, when do they call a meeting of debenture holders? They call a meeting of debenture holders in two situations. Situation number one, when debenture holders are requesting. But what do you think? One or two debenture holders are requesting. Will they call the meeting? Of course not. So how many debenture holders should request? Debenture holders who put together are holding at least 1/10 of the debentures. This much debentures have to make a written requisition, a written request. Then they will call a meeting of debenture holders. Also, if any bed has happened in the company, that is, any breach has happened in the company, any event has happened in the company, or any default has happened in the company which is going to affect the debenture holders, immediately the debenture trustee will call a debenture holders meeting and discuss it with them. So debenture trustees have three roles to play. Number one, they protect the interest of the debenture holders. Number two, they redress their grievances. Number three, they call a separate meeting of the debenture holders. All right. And when will they call a separate meeting of the debenture holders, guys? They will call a separate meeting if debenture holders who are holding at least 1/10 of the debentures by request the debenture holders meeting. They file a written request, then they will call a debenture holders meeting. Also, they will call a debenture holders meeting if there is any breach event or default in the company which is going to affect the debenture holders. Then also they will call a meeting of the debenture holders. Okay. Now listen to the next point. There are some persons who cannot be appointed as debenture trustees. Who cannot be appointed as debenture trustees? Number one, any person who beneficially holds shares in the company. Beneficially holds shares is not necessarily shareholder. Any person who has interest in the shares of the company. Like for example, let us say I want to buy shares of Reliance Industries Limited, but I don't want to buy shares in my own name. I give money to my driver. I tell the driver, you please buy shares of Reliance Industries Limited. So the driver becomes shareholder, but I am the one who has beneficial interest in the company. So I cannot be debenture trustee. Driver can be debenture trustee. Shareholders who don't have beneficial interest, they can be debenture trustee. Persons who have beneficial interest. Now here, the driver is holding shares for me. I am only going to enjoy the benefits of the shares. I have only given money to the driver and told the driver, you buy shares in your name. But in reality, I am only going to enjoy the benefits of the shares. So any person who has beneficial interest in the shares, any person who beneficially holds shares cannot be debenture trustee. Please don't misunderstand this as shareholder. Okay, shareholders who don't have beneficial interest. Driver is a shareholder. He doesn't have beneficial interest. He can be debenture trustee. Tell me, did you understand this? Yes, guys. Did you all understand this? Everybody's clear with this? Yes, shareholders who do not, shareholders who have beneficial interest, only they can't be debenture trustee. But shareholders who do not have beneficial interest, they cannot be. What am I saying? Shareholders who do not have beneficial interest, they can be debenture trustees. Only if you have beneficial interest, only then you cannot be debenture trustee. Okay, that's my first point. Now listen to my second point. Any person who is a promoter of the company, any person who is a director of the company, any person who is the KMP of the company, any person who is an officer or employee of the company. Now all of this of cash. Do you remember cash? company, associate, subsidiary, holding. So promoters of cash, directors of cash, KMP of cash, officers and employees of cash, they cannot be appointed as a debenture trustee. Then even their relatives can't be appointed as debenture trustee. Then any person who owes money to the company, or any person to whom the company owes money, all these persons can't be appointed as debenture trustee. Okay. Then any person who has given guarantee that don't worry, company will repay debentures. If company doesn't repay debentures, I will repay debentures. Any person who has given guarantee like this can't be appointed as debenture trustee. Also, any person who has any pecuniary relationship. Pecuniary relationship means if you have any monetary relationship with the company, basically you have entered into a lot of transactions with the company, you cannot be appointed as debenture trustee. Okay, guys. So these people cannot be debenture trustees. Number one, if any person has beneficial interest in the shares, if any person beneficially holds shares, this person cannot be appointed as a debenture trustee. Number two, promoter, director, KMP, officer, employee cannot be appointed as debenture trustee. Their relatives also can't be appointed as debenture trustee. If I owe money to the company owes money to me, we can't be appointed as debenture trustee. If I have given guarantee, don't worry, company will repay debentures. If company doesn't repay debentures, I will repay debentures. If I have given guarantee like that, I can't be appointed as debenture trustee. Also, if I have any material pecuniary relationship with the company, which means I am entering into a lot of transactions with the company, I cannot be appointed as debenture trustee. Okay, guys, just two more points relating to debenture trustees. Okay, in case the company's assets are falling less than its liabilities, which means company's assets are insufficient to meet the liabilities of the company, in that case the debenture trustee will file a petition to the tribunal. The debenture trustee will file a petition to the NCLT. NCLT will pass an order telling the company not to borrow more money. Already your liabilities are more than your assets. Last point, if the company has committed a default, which means the company is not redeeming the debentures or company is not paying interest and all, in that case the debenture trustee will file an application with the NCLT, and again the NCLT will pass an order on the company telling the company come on, redeem the debentures forthwith. Redeem means what? Repay the debentures immediately. The reason why I'm discussing these 2 points, I want to show you, here I use the word petition, here I use the word application. This is purposely done. These are the kind of words which you should be using. Here petition, here application. Understood, guys? Yes. So these were my I lost the count. These are all the important concepts relating to debentures. Got it, guys? One quick revision. Yes, come on. Sit up straight. We are not getting tired already. Come on, guys. Listen. From the rate of allotment within 6 months, I have to give debenture certificate to the debenture holders. Then we said the debentures can be secured. If they are secured, I have to give asset as security, which is sufficient to meet not only the debenture amount, but also to meet the interest amount. Then we learned that the asset which I have given as security, that asset should be a company's asset or associate company's asset or subsidiary company's asset or holding company's asset. Then we learned that the debenture redemption reserve concept we learned. We'll see how much debentures are outstanding. 10% of that we have to take from the profits and put into debenture redemption reserve. But this concept is not applicable to all India financial institutions, banks, NBFCs, HFC, financial institutions and listed companies. Then we said we'll see how much debentures are maturing in the current year. 15% of that, we'll take that much money and we will invest that much money into prescribed investments. By doing this, at least 15% of the money is ready. By 30th April itself, 15% of the money at least is ready for redemption. But this concept is not applicable to same all India financial institutions, banks and financial institutions, but it is also not applicable only to unlisted NBFC and unlisted housing finance company, which means it is applicable to other listed unlisted companies. Then we learned the maximum amount. At the maximum, the existing long-term loans, other than short-term loans, other than temporary loans, the other existing loans plus the debentures which the company now wants to issue, everything put together should be within paid-up share capital plus fee reserves plus securities premium. Then after that, we learned that in case the company is having debentures, if the company is going to issue more than 500 prospectus copies, see, every company doesn't require debenture trustee. When do you require debenture trustee? If you're going to issue more than 500 prospectus for debentures, that is when you need debenture trustees. Now, these debenture trustees will protect the interest of the debenture holders, redress their grievances, and call a meeting of debenture holders when, if the debenture holders holding at least 1/10 of the debentures request, or if any bid happens influence in the company. Then we learned who and all can't be debenture trustees. Then we learned if company's assets are less than liabilities, we will file a petition before NCLT. NCLT will order the company not to borrow more money. Then we learned if company is defaulting, that is, the company is not repaying the debentures or not paying the interest, NCLT will pass an order asking the company to redeem the debentures immediately. Perfect understanding, guys? Yes. So this was my entire discussion with you relating to debentures. All right. So with this, we are done learning with the 4 important concepts under the share capital chapter. Right, guys, we are learning set A. Okay. Now, similarly, we also have set B. Set B will be another set of important 50 questions which you will be handling. Like, for example, in the same share capital chapter, equity shares with differential rights. Even this is important. Then securities premium and discount. Section 50 to 53 is important. Sweat equity shares. Section 54 is important. Bonus issue. Section 63. Even this is important. Then refusal to register transfer and section 67 financial assistance. So these are the set B 50 questions. So first you will do set A with me, and then similarly set B you will do off on your own. All right, guys. So with this, we have finished 12 important concepts already. All right. Now listen, I'm taking you to the deposits chapter. And this is my target for today. I need to finish till the deposits chapter. All right. Under the deposits chapter, we're going to be discussing 4 concepts. Number 1, we will see what are all the exclusions from the deposits. What are all those transactions which will not be considered as deposits? Okay, listen to me. Concept number 13. What are the transactions which will not be considered as deposits? You must be aware that under the Companies Act, there is a huge list of transactions which are not considered as deposit. See, listen, from the deposits chapter, you will for sure get a 5 marks question. Okay, now this 5 marks question may be in the MCQs or it may be the descriptive part. Now, whatever it is, whether it is MCQ, whether it is descriptive part, 60% chance is that the question will be from the exclusions. And those exclusions only I'm going to be discussing with you. So are you understanding how important the exclusions are? 5 marks for sure. Out of those 5 marks will be 60% a question from the exclusions. So though these exclusions become extremely important, they have the highest chance of being asked in the examination from the deposits chapter. Now, what are the exclusions? Number 1, if the company has received any money from central government, state government, or local authority, this money will not be considered as deposit. Then number 2, this time company is receiving money from some other person, but central government or state government has given guarantee to this person that don't worry, company will repay money. If company doesn't repay, we will repay. Even this is not a deposit. Then number 3, this time the company is receiving any money from a foreign government, or the company is receiving money, let us say, from some foreign bank, or the company is receiving money from some multilateral financial institution like World Bank, IMF and all. So this money also will not be considered as deposit. Number 4, company is receiving money from some bank, or company is receiving money from some financial institution. Even this money will not be considered as deposit. Number 5, company is receiving money from some other company, that is intercorporate transactions. Even this money will not be considered as deposit. Okay. Then number 6, this time the company issued commercial paper to a person. Against commercial paper, this person has given money to the company. Any money which the company gets against commercial paper will not be considered as deposit. Then the next point, company received some money from an employee, and this money is within his annual salary. If it is within his annual salary, this money will not be considered as deposit. Then number 8, this time company got money from any director of the company or from relative of the director. This director or relative, condition number 1, they have given a declaration. What declaration? They have given a declaration that this money is out of own funds and this money is not out of borrowed funds. And also condition number 2, this person who is giving the money, all details about this money is properly disclosed. Properly disclosed where? Properly disclosed in the board report. So if all these conditions are fulfilled, any money which I get from directors and relatives will not be considered as deposit. Okay. Then the next point, the 9th point, this time company receives any money from any person. Okay. And this company happens to be a Nidhi company. If Nidhi company is getting any money from any person, this money will not be considered as deposit, because for Nidhi companies, we have totally different rules and regulations which are applicable. Then the next point, if my company is getting money from another person and the company is going to hold this money only as a trustee, which means company cannot use this money. This money is actually for the benefit of somebody else. The company is going to hold this money only as a trustee. And also this money does not carry any interest. This money will not be considered as deposit again. Company has received any money as trustee. This money is not carrying any interest. This money will not be considered as deposit. Okay, then the next point, the company receives any advance from customer. In day-to-day business, if the company receives any advance from any customer as a part of ordinary business, this advance will not be considered as deposit. Then the next point, this time what happens is the company wants to get a loan from a bank or from a financial institution, but this bank or financial institution has put a stipulation on the company. Stipulation means what? They have put a condition on the company. What condition? That the promoters should also give an unsecured loan to the company. So if the promoters have given an unsecured loan to the company because of a stipulation put by bank or financial institution, this unsecured loan will not be considered as deposit. But once the company repays this loan, once this loan is repaid, then the stipulation will not exist anymore. So in that case, we should return this unsecured loan. If we don't return this unsecured loan, then this unsecured loan will be considered as deposit. I'll repeat this point once again. Listen to me. The company wants a loan from a bank or from a public financial institution, but they have put a stipulation on the company that we will give you a loan, but for that condition, promoters of the company should also give the company an unsecured loan. This unsecured loan will not be considered as deposit. But once we have returned this loan, once we repay the bank's loan, the stipulation is not existing anymore, guys. So in that case, do we still need the unsecured loan? We don't need the unsecured loan. But if the company still keeps the unsecured loan, now it will be considered as a deposit. Now it will be considered as a deposit. Okay, then listen to my next point, point number M. This time, company has issued debentures or bonds to a person, and against debentures or bonds, the company has received money. Now we will see what kind of debentures, what kind of bonds. The debentures may either be compulsorily convertible debentures. They may be compulsorily convertible debentures, or they may be secured by a first charge. First charge means the debenture holders will have first right over the assets of the company. First charge, secured by a first charge, or they should be listed debentures. If they are bonds, they should either be compulsorily convertible or they should be secured by a first charge. Okay, here I don't have the concept of listed debentures. So in case I issue debentures or bonds, if I'm getting any money against debentures or bonds, the debentures should either be compulsorily convertible or they should be secured by a first charge or they should be listed debentures. If they're bonds, either they should be compulsorily convertible or secured by a first charge. Secured by first charge, that is important. Secured by first charge means you should be having first right over the assets of the company. Okay, guys. So this was my discussion regarding point number M. Then listen to my next point. We just have two more exclusions only. This time the company is a private company which is recognized as a startup by DIPP, Department of Industrial Policy and Promotion. This company has issued a convertible note to a person. Against this convertible note, this person has given money to the company. This convertible note is either convertible into equity shares or it will be repaid, which means it is not compulsorily convertible. Either it will be converted into equity shares or it will be repaid within maximum 10 years. Either it will be converted into equity shares or it will be repaid within maximum 10 years, and this money is at least 25 lakh rupees. And this money did not come in bits and pieces. This money came in as one single tranche. If all these conditions are fulfilled, this money will not be considered as deposit. Understanding? Company is a private company which is recognized as a startup by DIPP. This company has issued a convertible note. Against this convertible note, it is receiving money, at least 25 lakh rupees it is receiving in one single tranche. This money will not be considered as deposit. Okay, the last point, the company wanted to allot shares. So the company has received share application money. So we will see, when did the company receive the share application money? From the date of receipt of share application money, within 60 days, the company should actually allot the securities. If the company is unable to allot the securities within the next 15 days, it should refund the money. till this date, it will not be considered as deposit. Even after 15 days, if the company keeps the money, then after 15 days, it will be considered as a deposit. Understanding, from the date on which the company received the money, from that day, within 60 days, the company must actually allot the securities. If the company doesn't allot the security within 60 days, then within the next 15 days, it should refund the money. If it doesn't refund the money within the next 15 days, then thereafter, it will be considered as deposit. But till 75 days, it will not be considered as a deposit. It will be considered as a deposit only after the 15 days, only after the 60 plus 15, only after 75 days. But till here, it will not be considered as deposit. So these are your 15 exclusions. These exclusions, these cases will not be considered as deposits. Okay, what are the 15 exclusions, guys? One quick revision. Number one, if the company is getting any money from central government, state government, or local authority. Number two, company is getting money from any other person, but central government or state government is giving guarantee for repayment of that money. Number three, company is getting money from the foreign government or from the foreign bank or from a multilateral financial institution. Then number two, company is getting money from some bank or from some financial institution. Number five, company is getting money from some other company. Then company is getting money against commercial paper, or company is getting money from an employee which is within his annual salary. All this will not be considered as deposit. Also, if company is getting any money from directors or relatives who have given a declaration that this money is out of own funds and this money is not out of borrowed funds, also full and proper disclosure has been made into the full and proper disclosure has been put into the board report. Okay, in all these cases, we cannot. In all these cases, we cannot call it as deposit. Then on Nidhi companies, we can't apply deposit provisions. Then if the company has received any money, which the company is going to hold only as a trustee, and this money is not going to carry any interest also, this money will not be considered as deposit. Then if the company has received any advance money from a customer, even that will not be considered as a deposit. And finally, if the company has received any loan from, if the company wants a loan from a bank or a financial institution, but they are putting a stipulation on the company, we will give you a loan, but for that precondition, your promoters should give you an unsecured loan. If that's a sort of a situation which is existing, then this unsecured loan will not be considered as deposit. But once we repay this loan, the stipulation is not existing. So we don't need this unsecured loan. If we still keep this unsecured loan, now that unsecured loan will be considered as deposit. Then we learned, if company got money against debentures, compulsorily convertible or secured by first charge or listed, any one condition fulfilled, then that money will not be deposit. Or if the company gets money against bonds, which are compulsorily convertible or secured by first charge, it will not be considered as deposit. Then we learned, if company got money against convertible note, which is convertible or repayable within maximum 10 years, and we got money at least 25 lakh rupees, it will not be considered as a deposit. And finally, we learned, guys, from the date of receipt of share application money, we should allot the securities within 60 days. If we don't allot within 60 days, within the next 15 days, we should refund the money. If we don't refund the money within the next 15 days, thereafter it will be considered as deposit. Till then, it will not be considered as deposit. Okay, so this was our discussion regarding exclusions from deposits. Now listen, what's the maximum deposits which the company can accept? My next concept, my concept number 14, what is the maximum amount of deposits which the company can accept? Now see, it depends upon whether the company is accepting the deposits for a short-term period or is it accepting deposits for the long-term period. Short-term period means for it has to be minimum 3 months and maximum it will be how long? Maximum 6 months. Okay. Long-term means it will be minimum 6 months, but maximum it can be 36 months. So it all depends upon whether the company is accepting deposits for the short term or is the company accepting deposits for the long term. If the company is accepting deposits for short term, then we have only one single limit. The total deposits should be within 10% of paid up share capital plus free reserves plus securities premium. The limit is 10%. Okay. But if they are going to be long-term deposit, then it depends upon is the company accepting deposits from members or is the company accepting deposits from public. If the company is accepting deposits from the members, then the limit is generally 35%. The already existing deposits plus deposits which the company wants to accept, everything put together should be within 35% of paid up share capital plus free reserves plus securities premium. Okay, but if the company happens to be a private company, for private company the limit will be 100% of paid up share capital plus free reserves plus securities premium. But if the company happens to be an eligible company, for eligible company the limit will be 10%, up to 10% of paid up share capital plus free reserves plus securities premium. Okay, then what if the company wants to accept deposits from the public? If it wants to accept deposits from the public, then the limit is generally 25% of paid up share capital plus free reserves plus securities premium. But if the company happens to be a government company, for government company the limit is going to be 35% of paid up share capital plus free reserves plus securities premium. Now that we're discussing all this, simultaneously, let us also talk about eligible companies. Who are these eligible companies? Now, eligible companies are those companies which are, first of all, public companies. Okay, these public companies have a net worth of at least 100 crore rupees, or they have turnover of at least 500 crore rupees. Either a net worth of 100 crores or turnover of at least 500 crores. The number 3, we will see how much deposit are they accepting. If they are accepting deposit which is within section 181C limit, then they need just an ordinary resolution. But if they're going to accept more than section 181C limit, then they will need a special resolution. All these conditions have to be fulfilled, you will become an eligible company. So what do you mean by an eligible company? Number 1, you should be a public company. Then your net worth should be at least 100 crores or your turnover should be at least 500 crores. Then if you're accepting deposits which is within 181C limit, you have to pass an ordinary resolution. If you're accepting more than 181C limit, you have to pass a special resolution. Always remember, whenever we pass any special resolution, a copy of the special resolution we have to file with the ROC within 30 days. Okay, now that we're discussing about this, one more passing point, who can accept deposits from members? Any company can accept deposits from members, but which company can accept deposits from the public? Only eligible companies can accept deposits from the public. Okay, guys, so this flowchart is a very good summary of 2 to 3 things. Number 1, what is eligible company? Number 2, from whom can we accept deposits? Number 3, what's the tenure of deposit? And number 4, what's the maximum amount of deposits that we can accept? All right, guys, so this was our discussion regarding the maximum deposits from members and public, and we also spoke about eligible companies simultaneously. So with this, we're done with concept number 14 and 15. And now coming to one last concept for today about deposit repayment reserve, deposit receipts, registers, and returns. 4 small tiny concepts we have to discuss. First of all, deposit repayment reserve. Now you tell me, debenture redemption reserve, what is the number that comes to your mind? For debenture redemption reserve, 10%, right? Debenture redemption investment, what's the number that comes to your mind? 15%. Now deposit repayment reserve, 20%. So 10, 15, 20. Okay. So in deposit repayment reserve, what we will see is, we will see current year plus next year put together how much deposits are maturing. Current year and next year put together how much deposits are maturing. This much deposits into 20%, we have to go to a scheduled bank. In this scheduled bank, open a separate bank account. Call the separate bank account as deposit repayment reserve account. And in this account, we have to deposit so much money. We have to deposit so much money on or before 30th April of the current year. Same 30th April, do you remember we've also seen earlier? Same 30th April, we saw even under debenture redemption investment. Where is it? Here. Even debenture redemption investment, we saw 30th April, guys. Yes. So listen, under deposit repayment reserve, we will see current year and next year put together how much deposits are maturing. That much deposits into 20%. This much money we have to deposit into a separate bank account called deposit repayment reserve account on or before 30th April. This money we will use only for one purpose. And for what purpose will we use this money? To fully, we will use this money only for one purpose, which is to repay deposits. Okay. Then listen to my next concept. These deposits are going to carry interest, guys. What is the maximum interest that I can pay for these deposits? How much interest can I pay maximum for these deposits? At the maximum, I can pay only whatever is the maximum rate of interest which the RBI has fixed for NBFCs. RBI has fixed for NBFCs a certain maximum interest rate which NBFCs can pay. The same maximum interest rate which is applicable for NBFCs, that same maximum rate will also apply for deposits. Okay, so this was my second extra point. Now listen to my next point. See, we will see when did the company receive the money. So from the date of receipt of money, from that day, within 21 days, the company has to give a deposit receipt to the depositor. This deposit receipt will contain totally 5 things. The hint to remember the 5 things is drama. Number 1, it will contain the date of deposit. Number 2, it will contain the rate of interest. Number 3, it will contain the amount of deposit. Number 4, it will contain the maturity date. When will the deposit mature? And number 5, it will contain the address and the name of the depositor. Once we give the deposit receipt, from this date, from the date of giving the deposit receipt, within the next 7 days, the company has to make an entry in the deposit register. Company will maintain a deposit register in the registered office. Okay, so in this deposit register, the company has to make an entry within 7 days of giving the deposit receipt. In the deposit register, the company will write details like the name of the depositor, the same 5 things. In addition to this, the deposit receipt number. The deposit receipt number also has to be written into the deposit register. That is why we give the deposit receipt first and then we make an entry in the deposit register. Okay. Then also understand one more thing, guys. Whenever we maintain a register of deposit, for how long do we have to preserve it? This register we have to preserve for at least 8 years. We have to preserve for at least 8 years from the date on which the last entry was made in the register. When was the last entry made in the register? From that date, for 8 years, we have to preserve this register. Okay, so deposit repayment reserve, we will see current year, next year put together how much deposits are maturing. 20% of that we have to put into a separate bank account called deposit repayment reserve account on or before 30th April. Then maximum interest that we can pay for deposits is a maximum interest which RBI has prescribed for NBFCs. Then we learned deposit receipt has to be given within 21 days of receiving the money, which will contain 5 things: drama, date of deposit, rate of interest, amount of deposit, maturity date, and address and name of the depositor. From the date of giving the deposit receipt, within 7 days, we have to make an entry in the deposit register. This entry will also contain the deposit receipt number. This register we have to preserve for at least 8 years from the date on which the last entry is made in the register. Now, deposits can be secure deposits or they can be unsecured deposits. Okay, but if they are secure deposits, I can give assets of only the company as security. These assets should be only tangible assets. See, listen, generally I can give intangible assets also as security, but only for deposits. Only for deposits, I can give only tangible assets as security. I cannot give intangible. So debentures and all, give any kind of security, I don't care. Give even associate security. Give even subsidiary companies asset, I don't care. Give cash securities, company, associate, subsidiary holding, give any of their assets as security, tangible, intangible, it doesn't matter. But for deposits, when you're giving asset as security, it has to be only company's asset and it has to be only tangible asset. And even over here, the asset has to be sufficient to meet not only the deposit amount, it also has to be sufficient to meet the interest which is due on the deposit. It has to be sufficient to meet the deposit amount plus the interest amount. All right, guys, what if it is less? What if the value of the asset is less than this? Then you will call it as unsecured deposit. You have nothing called as partially secured deposit, either secured or unsecured. So if the value of this asset is enough for both of this, you will call it secured. If the value of the asset is less than this, you will call it as unsecured. So I can give any tangible asset of the company, but that asset should be sufficient to meet not only the deposit amount, it should also be sufficient to meet the interest amount. Okay, then one last point under deposits, we are supposed to prepare a deposit return. We are supposed to submit a deposit return in form number DPT3 with the ROC. This deposit return has to be submitted by 30th June of the next year, which means like for financial year 22-23, you will submit this deposit return on 30th June 2023. Okay, see, debenture redemption reserve, debenture redemption investment, deposit repayment reserve is all current year date. Okay, but the deposit return is next year. Not in 22-23. Next year, 30th June 2023, you will submit form DPT3. This has to be audited return, but it has to be audited DPT3. So we spoke about deposit repayment reserve, deposit receipt, deposit register, and deposit return. We've spoken about all these 4 things. Okay, guys, and one last point. What if the company doesn't repay deposits? What if the company commits a default in repayment of deposit? Then company will have to pay 18% per annum interest. If it doesn't repay deposits on time, it will have to pay 18% per annum interest. Crystal clear with this discussion, guys? Yes, so these are the extra points relating to deposits. All right, so with this, we have completed around 16 out of our 50 important concepts. The rest of our discussion we will take up in tomorrow's session. All right, guys. Yes, these 16 concepts, I'm sure you are confident. We've gone pretty much in depth. These 16 concepts I've discussed with you 360 degrees. Everything relating to these 16 concepts. If you're thorough with this much, nothing more is required. All right, so we'll close over here. I'm very sure it must have been a pretty tiring session for you. So we'll close over here. You take a small break after you finish the session and then get back to whatever studying you were doing. Okay, I'll see you again tomorrow at same 3 o'clock. And tomorrow we will take up the rest of the session, the rest of the concepts. Thank you, guys. Bye-bye.